Voluntary Lead Shepherd on Trafficking in Persons, Senior Officials Meeting on Transnational Crime. Her Excellency Yuyun Wahyuningrum, Representative of Indonesia to ASEAN Intergovernmental Commission on Human Rights, or AICHR. Professor Siobhán Mullally, UN Special Rapporteur on Trafficking in Persons, especially in women and children. Dr. Marika McAdam, author of the study on the implementation of the non-punishment principle in the ASEAN region. Dr. Lucia Pietropaoli, team leader, ASEAN Australia, counter-trafficking and her team. Country delegations, Your Excellencies, ladies and gentlemen. It is a great privilege to welcome you to this regional workshop to validate the findings of a new study on the implementation of the non-punishment principle in ASEAN region. The study was commissioned by Australia through the ASEAN-Australia Counter-Trafficking Program, or ASEAN-ACT. This is my first regional validation workshop engaging in ASEAN-ACT since commencing in my new role as First Secretary Development in Australia's mission to ASEAN. I'm pleased to meet you all, albeit virtually, and look forward to getting across this very important issue. We are delighted that the Voluntary Lead Shepherd on Trafficking in Persons and AICHR, Indonesia, have partnered with us to host this workshop, attended by government and non-government stakeholders from across the region. We are also extremely honoured to have the UN Special Rapporteur on Trafficking in Persons address us later in the program, and we thank her for her support of this study. The ASEAN Convention Against Trafficking in Persons, especially women and children, or ACTIP, obliges member states to implement the non-punishment principle in all counter-trafficking efforts and to ensure effective measures are in place to protect and assist victims of trafficking. The non-punishment principle infers that victims of trafficking should not be punished for crimes they may have committed in the course of being trafficked. Crimes that victims of trafficking are most commonly punished for include prostitution, drug trafficking, and drug production. Most ASEAN member states have taken steps to reflect the non-punishment principle for victims of trafficking in domestic legislation. However, implementation across the region, as it is globally, remains uneven. The study conducted by Dr. McAdam highlights good practices in applying the non-punishment principle in trafficking cases in ASEAN, as well as the practical challenges and constraints that hinder the full and consistent implementation of the principle in this region. The study was conducted over a 4-month period and involved consultation with government and non-government stakeholders in 6 ASEAN member states. I would like to thank you for your meaningful contributions to the roundtable discussions and for the honest and open reflections that were offered. The study is the first of its kind in the ASEAN region. We hope that the key findings and recommendations from the study, which will be presented shortly by Dr. McAdam, will be useful to all of you as policymakers and practitioners striving to implement the ACTIP. And we trust that the recommendations offered will provide clear and practical guidance on how to strengthen the implementation of the non-punishment principle in law, policy, and practice. Please be reassured that Australia's commitment to supporting ASEAN member states goes beyond commissioning research to inform policy reform. The ASEAN-ACT team is here to support both ASEAN bodies and national governments, as well as government and non-government actors, to work towards implementing these recommendations in a coordinated and systematic manner. The validation process is an important part of ASEAN-ACT research projects. It provides an opportunity for you to learn about the key findings and provide your perspectives prior to the finalisation of the study. We greatly value your contributions and perspectives on the complex issue of non-punishment. Once again, thank you for your participation today. I look forward to continuing and building strong partnerships with SOMTC, AICHR, and all of you here today to counter trafficking in persons in the ASEAN region. On behalf of the Australian government, I wish the workshop a great success. Thank you.
Thank you so much, First Secretary Karla Juranek, and we welcome your posting to the ASEAN region, and we look forward to more engagements with you. At this point, Excellencies, ladies and gentlemen, I am honored to invite Excellency Yuyun Wahyuningrum, the representative of Indonesia to the ASEAN Intergovernmental Commission on Human Rights and co-host of this workshop, to please deliver her remarks. Ibu Yuyun, you have the floor.
Thank you very much, Chair. Honorary Marcelo C. Morales, Assistant Secretary for International Relations and Other Interior Sector Concerns, Department of Interior and Local Government, SOMTC, Philippines. Ms. Karla Juranek, First Secretary for Development, Australian Mission to ASEAN, Department of Foreign Affairs and Trade. Professor Siobhán Mullally, UN Special Rapporteur on Trafficking in Persons, especially women and children. Dr. Lucia Pietropaoli, Team Leader, ASEAN-ACT, Dr. Marika McAdam, International Law and Policy Advisor, ASEAN-ACT. Distinguished participants, ladies and gentlemen, good afternoon. It is my pleasure to co-chair this event and welcome everyone to the Regional Validation Workshop, presenting key findings of the ASEAN-ACT study on the application of the non-punishment principle in ASEAN today. In this occasion, I would like to thank ASEAN-ACT for the initiative and all necessary arrangement to make this event possible. This initiative related to combating the initiative related to combating trafficking in person remain high in the agenda of the ASEAN Intergovernmental Commission of Human Rights, or AICHR. In its work on anti-trafficking measures, AICHR is tasked to set the norms or standards, provide policy supports for member states and ASEAN sectoral bodies, develop human rights strategies, engage stakeholders in dialogue and consultation, conduct research, and build the capacities of relevant actors working on addressing trafficking in person. One of the human rights strategies that was agreed in AICHR is to mainstream human rights in 3 ASEAN communities. In the case of anti-trafficking measures, AICHR aims to putting human rights at the heart of the prevention measures, protection of the victims, law enforcement and prosecution of the crimes of trafficking in person, and on regional and international cooperation and coordination. By way of mainstreaming human rights, it also means that we need to surface the protection of the rights of victims. AICHR is guided by international norms in relation to the state obligation to respect, protect, fulfill the right of victims, and at the same time contextualize them into the experiences of victims. Under Principle 11 of the UN Reparation Principles, the right of victims of human rights violation include the right to equal and effective access to justice, adequate, effective, prompt reparation from harm suffered, access to relevant information concerning violation and reparation mechanism to include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. In the case of trafficking in person, victims often held liable for unlawfully activities committed by them in consequence of their situation as victims, not only in relation to the specific forms of exploitation they might be subjected to, but also for incidental or consequential acts, namely any immigration, administrative, or civil offenses committed by them, either in the course of being trafficked or as a direct consequences of their trafficking situation. This includes where, for example, a victim is prosecuted for their possession of false documents or their illegal entry or stay in a country. Article 14.7 of the ASEAN Convention Against Trafficking in Person, especially women and children, introduced the non-punishment principle to victims of trafficking in person as one of the measures to protect the right of victims in states' efforts to counter trafficking. This also resonates with many existing international and regional norms on human rights. Non-punishment provisions are therefore precisely and crucially aimed at granting trafficking victims the protection they are legally entitled to, while at the same time preventing re-trafficking and punishing the perpetrators. AICHR is, of course, welcome all of this initiative to protect the right of victims of trafficking in person and effort to ensure that victims can restore their dignity, reputation, and rights. Distinguished participants, ladies and gentlemen, in my capacity as the representative of Indonesia to the AICHR, I have organized series of online consultations in the second half of 2021 with different stakeholders, including the victims, to listen their inputs, critiques, grievances, and recommendation on the state obligation on the role of regional organizations like ASEAN, and also the role of regional human rights mechanism like AICHR to ensure the rights of victims, right to remedy, access to justice, and regional referral services and system. Some of their aspirations have been reflected in number of concept notes of AICHR activities that were adopted by consensus. One of them is the regional consultation on the right to remedy, which we plan to organize this month. I'm also happy to inform you that AICHR will continue to focus on victim-centered measures in addressing trafficking in person in the region. After getting approval from the ASEAN Foreign Ministers meeting in August this year, AICHR will organize regional workshop on referral systems such as trafficking in person, violence against women and children in 2022. The discussion of non-punishment principle is indeed timely as AICHR is in the mid of implementing and designing its victim-oriented initiatives. Internationally, this topic gains more attention nowadays in the context of changing paradigm in addressing trafficking in person. Therefore, I'm looking forward to the fruitful discussion and to hear doable recommendation to be followed up by AICHR from this workshop. And thank you very much.
Thank you so much, Excellency Wahyuningrum, the representative of Indonesia to the ASEAN Intergovernmental Commission on Human Rights, for your meaningful remarks and for co-hosting this event and for your reassurances of AICHR's commitments to address trafficking in persons, and also for reminding us that the non-punishment principles is part of the rights-based approach to counter trafficking in persons. At this point, Excellencies, ladies and gentlemen, it is my honor to invite to the floor the co-chair of this workshop, Excellency Honorable Marcelo C. Morales, the Assistant Secretary for International Relations and other interior sector concerns of the Department of the Interior and Local Government of the Philippines, and SOMTC Philippines representative. Assistant Secretary Morales, you have the floor, sir.
Thank you, Director Kem. Let me first acknowledge the following. Ms Karla Juranek, First Secretary, Development of the Australia Mission to ASEAN, Department of Foreign Affairs and Trade. Her Excellency, Madam Yuyun Wahyuningrum, Representative of Indonesia to ASEAN Intergovernmental Commission on Human Rights. Dr. Lucia Pietropaoli, the team leader of the ASEAN-Australia Counter-Trafficking. Of course, our moderator for today, Director Archimedes Siguan, ASEAN Program Director of the ASEAN-ACT. His Excellency, Ambassador Bruce Concepcion, the Philippines Special Envoy on Transnational Crime, and Assistant Director Debbie Torres of the ILG NBOO. Distinguished colleagues, honored guests, ladies and gentlemen, a pleasant day to all of you. First and foremost, I would like to extend my deepest gratitude to the ASEAN-Australia Counter-Trafficking or ASEAN-ACT for providing us great assistance in organizing this regional validation workshop entitled Presenting Key Findings on the Non-Punishment Principle Study in ASEAN. Nowadays, threats are no longer limited to traditional security concerns such as armed conflict, territorial disputes, and other difficulties involving the use of hard power. There are also the existence of non-traditional dangers, which include natural disasters, infectious diseases like the COVID-19, and transnational crimes, all of which have a significant impact on our country's security, economy, and well-being. We understand that human trafficking, sometimes known as modern slavery, impacts millions of individuals through a variety of means, such as forced labor, sexual exploitation, child marriage, death bondage, and child soldiering. Human trafficking or trafficking in persons, according to a report, is one of the world's most profit-making organized crimes, producing more than $150 billion annually. Furthermore, obtaining data is difficult owing to claims that some occurrences of human trafficking are underreported and underdetected, or even undocumented, resulting in these cases being under-prosecuted or not prosecuted at all. It has also been said that due to the problem's complexity, it cannot be remedied by just a single player, such as the government, or by focusing on a particular aspect of it, such as solely addressing forced labor or sexual exploitation. However, through the ASEAN's counter-tip initiatives, such as the ASEAN Convention Against Trafficking in Persons, especially women and children, with its complementary ASEAN Plan of Action and the Bohol Tip Work Plan, among others, we are able to address issues of trafficking in persons with the support of our partners. This demonstrates how ASEAN member states' unity leads to joint actions on initiatives or to combat trafficking in persons in the region. As the voluntary lead shepherd for trafficking in persons, the Philippines wishes to convey its heartfelt gratitude to all member states for your active engagement, contributions, and unwavering support in combating transnational crimes. As we observe, victims of human trafficking are subjected to exploitation in various ways. Once victimized, as a result, they could engage in wrongdoings. These include involvement in sex trade, drug production or trafficking, possession or use of fraudulent documents, or entering another country illegally. Most cases, these victims are forced or otherwise compelled by traffickers to commit these crimes. In most cases, a victim is unaware that a law has been violated. Today, we are here gathered in this activity to present the key findings and recommendations of the study made regarding the non-punishment principle for the victims of trafficking in persons. Likewise, we aim to solicit feedback, suggestions, and all recommendations from both ASEAN government and non-government stakeholders through a productive discussion and information exchange. Let us continue working together to create a Southeast Asia marked by mutual trust and cooperation so that we can emerge as a strong and secure ASEAN. Each tiny step we take forward towards collaboration means more individuals are protected from the evils of trafficking in persons, and each contribution we make moves us to closer to our common goal of uniting ASEAN nations. One vision, one identity, one community. Thank you very much, and mabuhay tayong lahat.
Thank you so much, Honorable Co-Chair Assistant Secretary Morales, for your message with a strong call to action to working together toward a better one ASEAN. Mr. Co-Chair and Madam Co-Chair, at this point, may I please invite all our participants to a virtual photo session. Invite our participants to kindly switch on their cameras, their video cameras. And on my cue, my colleagues here at SOMTC Philippines will take a screenshot in 3, 2, and 1. And the other panel, 3, 2, and 1. And the last panel, Excellencies, ladies and gentlemen, please give us a nice smile. 3, 2, and 1. There you go. Thank you so much, Excellencies, ladies and gentlemen, for your beautiful smiles. We hope that this will be a productive workshop. I think your smiles alone will make this event successful. Now, Excellencies, ladies and gentlemen, it is my honor to ask the co-chairs to proceed with this workshop. Mr. Co-Chair, may I seek your approval to proceed with the next item in the agenda, the workshop proper. Assistant Secretary Morales, sir.
Thank you, Director Kem. In behalf of my co-chairs, I will hereby declare this meeting open.
Thank you.
Now proceed.
Thank you so much, Assistant Secretary Morales. On behalf of AICHR Indonesia, Excellency Wahyuningrum, may we please proceed with the next item in the agenda?
Yes, please, Chair.
Thank you so much, Ibu Yuyun. At this point, it is my honor to introduce the author of the study. Dr. Marika McAdam is an independent international law and policy advisor. She has worked on human trafficking and migrant smuggling issues globally with the United Nations and others, and is currently serving as an advisor to the ASEAN-Australia Counter-Trafficking Program, ASEAN-ACT. In her counter-trafficking work, she has trained law enforcers, prosecutors, and judges, addressed senators and parliamentarians, and carried out research globally on the challenges of implementing international law in practice. She is the author of several technical publications on rights-based criminal justice responses to counter-trafficking. May I please invite to the floor to present the findings and recommendations of the study on the implementation of the non-punishment principle for victims of human trafficking in ASEAN member states. Dr. Marika McAdam, you are recognized.
Thank you so much, Sir Kem, for the floor, and thank you to my colleagues for such a rich introduction to start this session off. I've been looking forward to this afternoon for many reasons. Key among them is the opportunity to thank my colleagues at ASEAN-ACT, but also the familiar faces on the screen now who gave of their time and their insights to the development of this study, and I can only hope that I have done them justice. This study has been among the most challenging and therefore also most rewarding. One of the reasons for that, I think, was the discovery that across the ASEAN region, we are absolutely united in the fact that this is a priority issue, and the commitment to step up our efforts on it and grapple with it is absolutely clear. So I'm really thrilled to have the opportunity to present these findings and discuss them with you today. So just to kick off with a brief overview, I know everyone has already received the executive summary, and I hope you've had a look at those brief pages, but I will present the findings and recommendations in short to facilitate our discussion of them. So the principle, in a nutshell, as we all know, the principle sets out that victims shouldn't be prosecuted or otherwise punished for criminal offences that they commit as a direct consequence of being trafficked. Now, the purpose of this, as Ibu Yuyun so well pointed out, is of course rights-based, that the key purpose of this is to protect victims of trafficking and to prevent their re-victimization. But if we look at this a bit more strategically, perhaps in service of SOMTC's agenda at combating transnational organized crime, we also have to understand that by protecting victims from punishment, we are also encouraging them to serve as witnesses against traffickers. And we know from evidence around the world, and including in our region, that well-protected victims make for stronger witnesses. So unfortunately, around the world, though, we know that victims are punished, and the consequences of that punishment are, of course, significant. For victims, their arrest and detention and potentially even prosecution can deny them access to justice and assistance, can delay their rehabilitation, and can result in further harm. For traffickers, however, punishment of victims is an excellent outcome. It plays into their hands, and indeed it deflects criminal justice attention away from them onto victims. So it really is to the benefit of traffickers when we prosecute and otherwise punish victims. So for the state then, for states who are committed to combating trafficking, including all of those represented here today, the result of punishing victims is that precious and sometimes scarce criminal justice resources are diverted away from serious organized criminals who are committing trafficking onto victims themselves. And the flow-on effect of that, of course, is their disincentivization to cooperate with criminal justice proceedings, which in turn can undermine our ability to prosecute traffickers. And this, of course, we know is a challenge compounded by the fact that around the world, we are heavily and overly relying on victim testimony as our key evidence. As Ibu Yuyun and other speakers at the outset have said, this is an issue that has gained increasing attention around the world. In many different forums. The Special Rapporteur, who I'm delighted will be joining us later today, has given significant attention to this issue in her tenure, and indeed her predecessor also really gave a lot of focus on this. We have the Interagency Cooperation Group on Trafficking in Persons, which released an issue paper on this last year. The OSCE has released a landmark report on this some years ago. The Council of Europe has given a lot of attention to this, including in its country assessments. The US State Department Trafficking in Persons reports. We know those annual reports are key for our response. It's including non-criminalization as a minimum standard for counter-trafficking. And at the European Court of Human Rights, we had a landmark case this year that found the United Kingdom, held them to account for punishing victims of trafficking. And more recently, a bullet point that I just reminded myself to add, of course, is the UN General Assembly political declaration, which reinforces this non-punishment principle. So clearly there is a strong commitment to this principle globally, which brought us at ASEAN-ACT to the question of what is being done in our ASEAN region on this issue. So the methodology we adopted to undertake this study, well, we did a desk review of resources that we found in ASEAN and indeed anywhere else. And then, as mentioned, we conducted a series of roundtables, as Karla mentioned. We carried out 12 roundtable discussions across 6 countries. And again, many of you are represented on that call, and I hope you enjoyed them as much as I did. Those conversations were rich and dynamic, and they involved 197 people, mostly from government, but also from non-government. Also, in addition to that, I carried out some individual in-depth interviews with experts on this particular issue, and also had the privilege of participating in several events at the international level that gave me a great deal of insight into this report. Of course, all studies have limitations, and this one discovered that there is a dearth of data on this issue. Unfortunately, not all countries participated in roundtables, so we've had to piece together some information beyond roundtables. And of course, it's become a bit boring to mention the limitations that COVID throws at us, but happily, we are doing well. And again, I can't thank my ASEAN-ACT colleagues enough for their support to host hybrid meetings in so many countries and achieve such strong participation. So the outcome of this work was a study that has landed in 3 parts that I'm going to very briefly talk you through. The first part talks about the sources of international law. The second looks at the findings that emerged across the region in all 10 ASEAN countries. And finally, part 3 is where I offer 26 recommendations for your consideration and indeed your adaptation to your country contexts. So part 1, extremely briefly, and as my colleagues have already alluded to, in international law, interestingly, the Trafficking in Persons Protocol does not explicitly contain the non-punishment principle, but rather it finds expression in the UN recommended principles and guidelines, as well as resolutions from the Conference of Parties to the United Nations Transnational Organized Crime Convention. The Working Group on the Trafficking in Persons Protocol has emphasize this principle again and again. Significantly too, we have Security Council resolutions that explicitly call on states not to punish victims of trafficking. Recently, the Special Rapporteur on Trafficking presented her report to the 47th Human Rights Committee on this issue of non-punishment, and I was glad to participate in that process too. And of course, in more hard law, we have an explicit provision in the Forced Labor Convention, only of course relevant to forced labor, not other forms of trafficking. And at the regional level, we have in Europe extremely strong provisions in the Council of Europe Convention and the EU directive. In Africa, we also have instruments that explicitly talk about non-punishment, as indeed in the Americas. But of more relevance to us is what we can be proud of, and our course can be steered by, being the ASEAN Convention Against Trafficking in Persons that was mentioned by Yuyun as well. Article 14.7 invites states, or rather calls states to consider not holding victims of trafficking criminally or administratively liable for acts they've commit in the course of being trafficked. And again, I think this is one of the key provisions we can emphasize when we in this region talk about how the ASEAN legislation exceeds the international standard. It's provisions like this that we can point to with some enthusiasm. Then, of course, all of this translates into the domestic legislation in the ASEAN region, and most states have an explicit non-punishment provision in their legislation, which is gratifying to see and interesting to see the different approaches taken to those provisions in law. Now, trying to put something simply that may sound quite complex, where international law captures the non-punishment provision, it takes one of two models. One is the compulsion model that understands the non-punishment principle to apply when the crimes the victim has committed were carried out under a level of coercion or under duress. The other model, which is the broader model and indeed the more popular model, is it establishes the link between the victim's offending and the non-punishment principle by saying, well, those criminal acts that victim commit were as a result of the trafficking. So in other words, the nexus between the offending and the non-punishment principle are easier to establish under that model. So, and that causation model is indeed what the ASEAN Convention has adopted, and most states in ASEAN in their domestic legislation have taken that approach, but the approaches vary around the world. And again, more information about this in the paper. So the second part of the paper is the findings, what we learned from the implementation of this principle in law, policy, and practice in ASEAN member states. Now, here is a snapshot of where there are provisions, what those limitations, what the limitations to the provisions are, and which model has been applied. So from this, you can see that most countries in the ASEAN region adopt the causation model. So that's the broader model, and indeed the one that a lot of international scholars and UN will advise is the one taken. However, some of those laws are limited in the sense that they only apply to some offences. So they will protect victims from prosecution for immigration-related offences or prostitution-related offences, but may not expand to capture all the offences that a victim may commit in the course of being trafficked. And then there are some other variations to those two models, including the approach taken by Thailand, which that doesn't clearly take one or the other approach, but takes a different model. So that's just a snapshot. But for the remainder of the discussion, I'd like to get into the generalized findings that emerged that we can then speak to, and I'd like to get your feedback on them. So the way I organized this incredibly rich information that you all provided me with in the course of our many, many hours together is to categorize all of that information into these categories. So how the principle is interpreted, how it's applied, what the challenges are in practice of applying the principle, and then looking at how victims are punished in practice or not. So on the first, and forgive me for my very text-heavy slides, these are for my benefit, not yours. So don't feel the need to read them. This is just to keep myself on track. So on the interpretation, interestingly, there were very different understandings of how the link between the non-punishment principle and the offence relates to the trafficking. So, and that was true not just between countries, but also within countries. So what was striking in that is that the prevailing view was that the offence should be the result of some sort of coercion. The victim should be somehow compelled to commit it. And that was true even in those jurisdictions where the broader model is taken in the law. There was also, though, happily, a strong understanding that where we're talking about a victim being coerced or where there's compulsion, that understanding should be broad and should reach to capture all of the means that traffickers may potentially use. And by that, of course, we mean in terms of act, means, and purpose. We all know as counter-trafficking practitioners that some of the means used may not necessarily be force, but they also may be more subtle. And there was an understanding among practitioners across countries that we are understanding coercion and compulsion to be broadly construed in line with trafficking. There were, however, different views on the scope of the non-punishment protection. Some were of the view that the protection should be limited to only capture certain offences, for instance, immigration related or prostitution related, where a victim has been trafficked into the sex industry. Others took different approaches again. Concerns were expressed, though, that if we allow the non-punishment protection to be construed too broadly, that serious offences may be captured within that. And then others were of the view that, well, serious offences should be captured within it, where a victim is not a free agent. So in other words, opinions on this point varied significantly. But across all countries, the need for guidance to interpret the non-punishment principle was emphasized. And this was raised again and again. And points were made here about the need to make sure that guidance isn't just available in the central provincial levels, but is also made available beyond that in more remote areas that may be often overlooked by counter-trafficking response. There was a call to make sure that the guidance that is made available reconcile various pieces of legislation. For instance, the counter-trafficking legislation should be reconciled with those pieces of legislation under which victims may be prosecuted, for instance, drug-related or immigration-related or otherwise. And also that guidance should emphasize very loudly that the principle should be applied at the outset upon the identification of a potential trafficked victim. And that's key and was a recurring theme through all the discussions. So moving from interpretation to application, it was interesting to note that where the non-punishment principle is applied, it's very often not as a direct conscious application of the law. So it's a practice that may happen to protect victims from punishment, but not necessarily because the legislation says so, and not necessarily because those who are acting in the interests of victims are aware that there is this obligation and this opportunity in the law. But many practitioners said there are no cases of victims being punished. Others were adamant that there are cases of victims being punished. And I think this speaks a little bit to the nature and the challenge of the issue, because the truth is globally, it's very difficult to say whether people who are currently perhaps incarcerated are unidentified victims of trafficking. So this speaks to the measure of our challenge. A key part of the discussion on the application of the principle was the role of criminal justice practitioners. And here it was discovered that they have significant discretion in whether they lay or pursue charges. But the challenge here is that they may be unfamiliar with the principle. They may not understand what its purpose is, and they may not understand what their role is in applying it and upholding this obligation. And here some of the challenges that I found really striking was the fact that practitioners are, of course, trained to pursue charges, and they may be more likely, of course, to lay a charge under the criminal code rather than to not lay a charge on the basis of a non-punishment provision in counter-trafficking legislation. And this resonated with me in work that I've done in regions outside of ASEAN, where many practitioners tell me, investigators here, they know the criminal code. They don't know the ins and outs of standalone trafficking legislation. So how do we bring those together? And also the intuitive or counterintuitive call to not punish offenders is a challenging one, because we are sending criminal justice practitioners out there to confront offenders. And now, of course, we are calling on them to not punish offenders. This is a challenging factor for us to address. It was clearly recognized that the non-punishment principle should apply in all stages. However, there was a call for clarity on what that actually looks like, and how we link the identification of victims of trafficking with their non-prosecution, and how that plays out in practice. Another key challenge, and one that I'm extremely excited to talk to you about, is that of international cooperation. Now, many bilateral agreements between states within ASEAN, but also between ASEAN and other states, have explicit provisions that refer to non-punishment. But questions were raised about whether those provisions are applied in practice. Concerns were also raised that they may apply again only to some offences, such as immigration, prostitution, or again may only apply to some victims, specifically women and children, leaving male victims of trafficking, adult male, vulnerable to being punished. So here the call was to harmonize understanding between parties so that someone who is recognized as a victim in one country can be protected from punishment in both jurisdictions. But of course, a lot of this goes on to practical challenges of implementation, and some of this relates to procedural challenges, jurisdictional challenges, particularly in the maritime context, which is one that I know we all grapple with, but is one of acute priority concern given exploitation of fishers and seafarers. And so all of these were raised as key challenges that we have to address, not just at the formal level, but also at the practitioner to practitioner level. And then again and again, the issue of victim identification emerged. And I think this would be true if we were talking about any other issue, because victim identification is, of course, key to our ability to combat trafficking and to protect its victims. If we can't identify victims, we cannot protect them. So this consideration was raised as being a critical reason why victims may be prosecuted rather than protected. And here it emerged quite strongly that the context that victims are encountered is crucial. So for instance, in the context of raids on workplaces where victims of trafficking may be, including brothels, including places where foreign migrant laborers may be exploited, often the ways in which those raids are carried out are not conducive to effective identification, and the people carrying out those raids may be looking for offenders, not for victims. So those contexts are absolutely key to confront in order to strengthen our capacity on this. And a related point to this is the fact, and this was a finding that exists beyond ASEAN as well as within ASEAN, that once a victim enters the criminal justice system as an offender, it is very, very difficult to then divert them into protection channels. And so this, I think, raises the need to confront opportunities to protect and identify across the criminal justice system, ideally at the outset to avoid victims ever entering the criminal justice system. But where that is not possible, we need to make sure that across the whole process, criminal justice practitioners can identify victims of trafficking. And of course, unsurprisingly, the under-identification risks were noted as being quite prevalent outside of the context of trafficking for sexual exploitation and of male victims. And we know that around the world, there is a great deal of attention on trafficking for sexual exploitation, often overlooking other forms of exploitation, and a focus on women and children, often overlooking the exploitation of male victims. Also on victim identification, again, there was a lot of discussion on this. the emphasis then became on the need to really take a concerted, deliberate focus on our capacity building efforts to sensitize all manner of criminal justice practitioners to the definition of trafficking so they can identify it, the interplay of its elements, the acts, the means, and the purposes, and the irrelevance of victim consent. Presumptions of victimhood and minority were also emphasized here. And a key finding too was that victim identification aids in victim non-punishment, and victim non-punishment aids in victim identification. Excuse me. In other words, where victims are treated and protected as victims, they're more likely to be identified, and they're less likely to be punished. And that's a cycle that is both key for protection and for prosecution of traffickers. Excuse me. So victim punishment in practice. As my colleagues said at the beginning, the crimes for which victims are most often prosecuted relate to immigration-related offences and prostitution-related offences. Those are the most prevalent types of offence that victims are punished for. Beyond that, of course, we have their involvement in drug offences, whether using it, producing it, or indeed trafficking it. There's also offences that they may commit in the course of trying to escape trafficking. Examples were offered, indeed, including of manslaughter or even murder. And a common scenario that is one, unfortunately, that we see all around the world is where victims graduate to become perpetrators of trafficking themselves, often, for instance, by recruiting others in to replace them so they can graduate away from being exploited to become the recruiter or the controller. Therefore, we know that many victims of trafficking may be vulnerable to being prosecuted as traffickers. The punishment too of victims in the fishing industry was raised as a key concern. And there was some discussion too on terrorism-related offences. And this here really raises some key conceptual and practical issues, that the slipping point between where a victim is a perpetrator is incredibly complex when vulnerable people are trafficked to commit abhorrent crimes, including terrorism. Another interesting discussion related to the misuse of anti-trafficking legislation to criminalize women in the sex industry. Now, while they may not be victims of trafficking, of course, the risk here significantly goes up. That where we are prosecuting people involved in the sex industry and where we are not effectively identifying victims of trafficking among them, here we have a key storm of factors that raise the risk that we're punishing victims of trafficking. And there was also discussion of victims of trafficking from the ASEAN region who were trafficked abroad, being punished for a range of offences, including outside of the ASEAN region. And those risks were notably higher in those jurisdictions that criminalize and stigmatize irregular migration. So concern here that victims of trafficking outside the ASEAN region, and indeed within it, are seen as irregular migrants and seen as the criminal element rather than being recognized as victims. So the key point to emerge on that was the need to strengthen cooperation and harmonize understanding between countries where victims come from and go to. And again, on victim punishment, punishment of child victims was considered of key concern, with examples raised even of children being prosecuted for trafficking other children. Again, the presumption of minority was stressed here in screening and identification. So when in doubt that a person may be a child, they should be treated as one for the purpose of protection and further identification. But concerns were raised that victim offenders may have been classified as children in conflict with the law rather than victims of trafficking. And some discussions were raised here about the role that the age of criminal responsibility plays in protecting child victim offenders from punishment. Interesting discussions too about how punishment of victims is part of the modus operandi of traffickers, how they may strategically make victims commit crimes to become complicit and to avoid that victims will seek help, because who will believe them? Who will help them? Because they are criminals too. And this is, again, something that we have to address in our criminal justice response and our relationship building with victims. The misuse by traffickers and other exploiters of defamation and libel offences to deflect the risk of being punished spoke to the power imbalance between offenders and victims, and again is a key challenge in the region and elsewhere. And then, of course, the threats of punishment being used as a tactic to control victims, which we see all over the world, where victims are too scared of authorities and don't trust them. And often that is a narrative fed to them by traffickers to their own benefit. And then there were interesting discussions about how the threat of punishment can actually play a role in the corruption that facilitates trafficking, and where corrupt officials can benefit financially and otherwise by threatening punishment of victims who would otherwise be able to seek help. Or indeed, punishment may be used as a tool of convenience, in other words, to keep a person in a jurisdiction rather than having to bring them back and go through international cooperation processes to achieve their testimony as evidence. The risk that victims face for drug-related offences was a key discussion, for obvious reasons, including the use of drug use to control victims, as well as trafficking of victims to commit drug trafficking, which around the world we know is a really effective way that organised criminals can reduce the risk of being prosecuted themselves by placing victims in the firing line and in the sights of criminal justice actors. Here, strict liability approaches to drug offences and wars on drugs were raised as being of concern, where they don't factor in the complexity of human trafficking and victims who may be caught up in this phenomenon. And of course, here we are looking really at the most grave risks. We are looking at the risk of victims of trafficking facing corporal and capital punishment. We know of corporal punishment of people who are involved in the sex industry, who may indeed be victims of trafficking. We know of capital punishment for people involved as drug mules. And of course, the current case of Mary Jane Veloso was a topic of discussion in some of the roundtable discussions as being illustrative of these very issues that we're talking about. So this brings me to the end of this session, and I'd like to now turn to you for your reflections and to find out whether you would like to add or clarify anything or add any nuance. And for this, I will turn to Kem to facilitate that discussion. And I thank you in the meantime for your attention.
Thank you so much, Marika, for a detailed discussion of the key findings of the study. I think in trying to look at the problem, we discovered more problems, if I may say so naively, Marika, but we did discover these findings to be really challenging. Now we turn to our participants, also including our co-chairs, Ibu Yuyun and Excellency ASEC Morales, if they have comments. We'll be happy to hear the insights of everyone in the room, to provide your comments if you have anything to add, clarify on the presented key findings, and if you also have any additional comments to the findings of the study. We'll be happy if you wish to be recognized, kindly press the raise hand button, or you could also type in your questions or comments in the chat box. Now, while waiting for you to formulate your thoughts, Excellencies, ladies and gentlemen, distinguished participants, may we please invite you to have a look at the chat box. There you will find the link to the attendance sheet, so that we would know where to send your certificates of participation. You can go to the chat box and then kindly fill out the attendance sheet. And there, we'll ask for your email, and then we will use your email to send your certificates of participation. Now, going back to the study, Marika, if I may be so bold as to ask the first question, how do we relate the non-punishment principle to the issue of conditionality in victim identification and in the management of trafficking cases? Did we in the study find any relationship in the conditionality issue and in the non-punishment principle, Marika?
Not explicitly, Kim. It didn't come up at all, but I suspect you are asking because you see a link yourself. Do you want to elaborate on where you think that link may be?
Yes, Marika, and thank you for putting me on the spot here, but that is, I think, one of the dangers of being the moderator in a workshop like this. Well, I see that in some jurisdictions and in my early work in facilitating the transnational investigative cooperation on trafficking in persons cases, there were some issues where victims identified as victims would not be released in detention if they do not cooperate in the criminal justice process. And ergo, non-application of the non-punishment principles. And we have seen this in some jurisdictions in the course of our facilitation of the bilateral police-to-police cooperation of the different ASEAN member states. So I'm surprised that we have found little connection in the study, but perhaps if our participants could refute these observations from this humble moderator, we would be happy to entertain any thoughts.
Well, I mean, Kim, there is obviously a connection, I think, between those two key principles. It wasn't explicitly discussed, but obviously it's key that victim protection should not be conditional on participation or not. But I think the key discussion when it came to that part of the process was that it related to the identification at the outset. So I think when we are not identifying, it's not only those rights that are denied, it's several others. And so I guess that's an awkward way of saying, of course, there is a connection, but it's not one that we explicitly unpacked, or indeed that was raised by participants at any length. Anyway, purpose is not for us to discuss. Purpose is to hear from others.
Yes. So may we hear now from our participants if you have any thoughts about the presentation of Marika on the key findings of this study. I see that Ibu Yuyun is looking intently at the screen. Madam Co-Chair, please. I know that you have cogent thoughts at this point. You are welcome to share them at this time. Ibu Yuyun, please. Unfortunately, we cannot hear Ibu Yuyun. No, we still can't hear Ibu Yuyun. Sorry, Ibu, there seems to be an issue with your audio. Yep, we'll fix your microphone, Ibu. Just to check, Marika, if you can unmute yourself and we can hear from you.
Yeah, I think the problem is at Ibu Yuyun's side, which is a shame because before the sound was perfect.
Yes.
Can you hear me now?
Yes, we can hear you now. Please go ahead, Ibu.
I'm actually waiting for participants to ask question or to seek for further clarification. I've been reading a number of reports on this. At the moment, I'm still, I really like the idea of non-punishment principle. And I'm actually wondering how it come to the practice. Well, Marika mentioned all the examples already, but I'm wondering if someone from the participants working on fishery industries, perhaps how this useful this principle, and how do you think the challenges in applying this principles, especially for those who are victim of trafficking, but they are remotely located, like for instance, those who are in fishery industries. Marika mentioned earlier about the case of drug trafficking, as number of women organization here in Indonesia also dealing with. Perhaps we would like to hear from the participants on number of cases, and perhaps those who are working on children. How do you think this would be helpful, or what would be further challenges?
Marika, did you hear the question from Yuyun?
I absolutely did hear the question, Kim, and I'm happy that it wasn't directed to me. It was actually directed to other participants, and I was fully in support of the question. I think that the challenges relating to the fishing industry particularly raise a lot of quite unique challenges because of the landscape, both physical and also jurisdictional, but also it was an area where there were some good practices emerging, where victims had been encountered and protected, but also concerns that victims have not been identified and were indeed prosecuted for things like IUU, fishing, and indeed for migration offences. So it really does show up two sides of things. But I think key, it also highlights the international cooperation challenges I was talking about, because invariably you have more than one state involved. We have the state of nationality of the fisherman, we have the flag state of the fishing vessel, we have the port state potentially, we have coastal states. So this really is a call for harmonized efforts and understanding of this principle, whether we are there yet or not, or whether we can share some practical insight on that. I hand to my fellow panelists, or not panelists, or my fellow participants on this.
Thank you so much, Marika. Yes, we'd be happy for our participants to respond to those comments from Ibu Yuyun and a question, and also the comments from Marika, including the key findings of the study. And in the meantime, I know that maybe some of our participants are still formulating their questions. I'd like to call on first Excellency Chubun Eng of the NCCT Cambodia to give us some of her thoughts at this point. May we hear from you, Excellency Chubun Eng, please. You can unmute, Excellency, your microphone.
Okay, thank you so much. And Excellencies, co-chair from SOMTC, I as Australian. And ladies and gentlemen, I just received the presentation, and I appreciate the Marika McAdam, comprehensive finding, and I just have the receive, the table that Cambodia have no nothing, responding to the principle. So I just think that the practice, because of ratify the UN Convention on the transnational organized crime, also the and also ASEAN Convention and plan, and we practice, and I can say that have the set up the national policy, for identification of victim, as a big provision, because we think that Cambodia, we have to identify the victim before sending them the court, what we call the case to the court. And we would like to provide them the support, especially for the legal support, and have to identify and consider them as suspected victim first. And we proceed the court case to the prosecution. And at that time, you know, we found our people, especially the one who are detained, you know, at the destination country, many of them are undocumented migrants. And we are very exciting because many of them, you know, just have been detained, you know, long time, and we as the sending country, we do not know what are the case they accuse. And for us, we think that before getting the process to the court, you know, we had to identify them first, because we do not know who they are. You know, they are the real victim or they are the offenders, because sometimes after the identification based on the law, you know, because we have the law and based on the protocol, you know, the Palermo protocol definition, so we can find the component, you know, can say we can conclude that they are victim or not. But at that time, you know, at the beginning, at least we have to consider them as suspected victim first. And we provide them support. Even later on, you know, we found that they are not the victim, but at least we have providing the support beforehand, you know, and we proceed the legal support to providing them. So I think that without victim identification, we cannot just say that we can punish or not punish. So that is why Cambodia, we try to establish the guideline for victim identification since 2015, you know. Even right now, we do not have yet, you know, the separate law or the extent law, you know, for the talking about the what we call the sorry. We talk about the non-punishment principle, you know, in ASEAN. We do not have the separate law, but I can say that right now we just try to focus and enforce the guideline, and we provide the training throughout the country, and we try to implement this, because we think that victim identification is very important, especially like you said that for all people who are victimized by the trafficking in person, including children, men, women, or any gender, you know, that we cannot just say that, oh, they are offender or they are victim without any identification. That is why I can say that even we do not have any extant law, you know, or some kind of practice to indicate that the non-punishment for the victim of trafficking in person, but we try to focus on how to identify the victim and to find the real victim and provide the support to them before send them to the court, you know, or we just try to advocate them, you know, to collaborate with us to find the offender rather than just punish the victim. Yeah. So I just have some declaration like this. Thank you so much, Marika.
Thank you, Madam, for emphasizing that point. And indeed, I have to say, Cambodia has so many guidelines on these issues that are listed in the full report, because there are really, Cambodia, I think, has got, I'm sometimes worried I haven't found all the guidelines that there are. So I commend your efforts on that. And thank you too for raising the points about legislation not necessarily being a measure of how something is applied, because one of the things I've certainly learned in working in counter trafficking is that many countries have a law that they don't necessarily apply. Other countries don't have a law but are still taking actions. So I think the law is one part of a more complex puzzle, and thank you very much for raising that point too.
And thank you so much.
Yes, thank you so much, Excellency Chubuneng and Marika, also for reacting to the inputs from Excellency Chubuneng. I think I keep reminding myself that we are in a validation workshop, Excellencies, ladies and gentlemen, dear participants. So we're here to validate the findings of the study which was conducted by Marika. And I think what Excellency Chubuneng has said validates what has been said in the findings, that victim identification is critical to non-punishment of victims of trafficking. And along this context, the non-punishment and victim identification are really very closely related to each other. And I recognize that there are some questions and some inputs in the chat box, but Co-Chair Assistant Secretary Morales placed the card of the host. So I'm going to first recognize Assistant Secretary Morales to go to the floor. Asik Morales, please.
Thank you, Kem. Good afternoon, Ms. Marika. Thank you for your comprehensive presentation. In the Philippines, the legislators want to increase or classify the offense on child trafficking as non-bailable offense, which would mean increasing penalties. Those found guilty of child trafficking and making it a capital offense, which is it's tantamount to life imprisonment. Under the present law, violators face 15 years of imprisonment plus fines amounting to a minimum of 500,000 pesos to 1 million pesos. So, and victims sometimes refuse to cooperate with the investigators or prosecutors because of fear of reprisals from the violators of this trafficking, who are mostly members of an organized crime group. So my question is, do you think the Philippines is going in the right direction by increasing the penalty of child trafficking and eventually making it a deterrent for those would-be child trafficking violators?
Thank you, Assistant Secretary Morales, for the very complex question. I'm a bit hesitant to venture an opinion because it's a question that is bigger than the issue of non-punishment. We're talking about non-punishment of victims of trafficking, not punishment of convicted traffickers. So in a sense, it's a separate issue. I think, though, that questions need to be asked about severity of sentences and whether they have a deterrent impact. I think there's a lot of science that could be looked into to determine whether that is effective. And the more severe the sentences, of course, the more infallible the legal decisions need to be. And I don't know of any legal system that is infallible. So I think that there are some risks to weigh up there. But again, if there is a link with the issue of non-punishment of victims themselves that I'm not missing, then please, I'd like to address that. But in the meantime, perhaps we can discuss beyond this setting, because it's an interesting commitment, and it clearly expresses the Philippines' commitment to address this issue of child trafficking, which we all know is a rising one that we haven't done a particularly good job at doing. But I'm yet to be convinced that the criminal justice process alone, by increasing severity of sentences, is the solution to this problem.
Thank you so much, Marika and Assistant Secretary Morales, for raising the issue of child trafficking and sentencing, severity of punishment in trafficking in persons cases. I now recognize additional comments coming into the chat box, but instead of just reading one of the comments from Undersecretary Suyuhaida of NSO MAPO Malaysia, may I please recognize and invite Yusek Puan Suyuhaida, please, to come into the floor and ask her question. The one that you type in the chat box. Puan Suyuhaida, you are recognized, please, and you have the floor, madam.
All right. Thank you, Cam, and thank you, Dr. Marika, for the excellent presentation and sharing of the findings. I just would like to ask regarding the drug mules. Is there any cases in any countries that you have come across in which the victims or the drug mules has also been identified as victims of trafficking? And if so, how the identification process is done, and how the overall process for that? Because we don't really have that kind of situation in Malaysia, because they are dealt with in different laws. So perhaps it will be something that can enlighten the practitioners here, if that is the best practices at international area. So thank you, Cam. Thank you, Dr. Marika.
Thank you, Suyuhaida. It's always lovely to see you, even though you throw big, complex questions at me. Thank you for that question, Suyuhaida. I would expect no less from you. The answer is yes, there have been cases in many jurisdictions, including in ASEAN, but also elsewhere, where drug mules have been recognized as victims of trafficking, because a few different things are coming together here. We know, for instance, that traffickers traffic people into criminal activities. We know that they do this so they can traffic drugs, essentially, without having any risk to themselves. But it takes a great deal of skill to recognize that a victim of trafficking is actually the offender before us, the drug trafficker before us, is a victim of trafficking. And as you say, it requires us to bring laws together, requires us to look at the counter-trafficking legislation alongside the drug offenses. But I think you're asking about good practice. Good practice here that's recognized globally is to not limit the non-punishment principle to only a category of offense. We know that victims can be trafficked in a multitude of ways, by a multitude of means, and to perpetrate different offenses. So we shouldn't exclude from our protection a person, regardless of what the offense is. Now, that is not to say that every drug mule will be recognized as a victim of trafficking, because there are drug mules who are not victims of trafficking. So how do we recognize the ones that are and make sure that we are not punishing them? And this, I think, speaks to the challenge that we all face. And I'm going to phrase this very badly, Suyuhaida, but we have the wrong people in the room. We don't need to be training counter-trafficking people to identify counter-trafficking. We need to also be training investigators of drug offenses to recognize victims of trafficking. We need to be making sure that the ability to recognize a potential victim of trafficking is in the hands of investigators of other crimes, whether migration crimes, whether drug crimes, whether sexual offenses. We need to make sure that we are not missing anyone, because the consequences of missing a person, well, we know those, we see them played out. So I think what you've hit on there should be the ultimate test by which we measure our ability to apply this principle in practice. And again, it's not the non-punishment principle is not a blanket immunity, but we have to be applying it in all spaces, because all victims of trafficking can be capable of committing all types of crime, and the protection should apply where there is a link between their offence and their trafficking. And right there, you've raised the key test and challenge for us. But yes, those cases exist in different jurisdictions.
Thank you so much, Marika and Puan Seyuhaida. I think the question from Puan Seyuhaida validates one of the findings of that study, that this is an issue also in drug mule cases on trafficking and drug trafficking, some relationship in these two crime types. The chat room is on fire, Marika, and we have 2 hands raised. I'll first go to LSCW. Soka, please, you're recognized from Cambodia. Kindly unmute and turn on your microphone. Please go ahead.
Thank you, Chair, and good afternoon, everyone. My name is Soka. I'm working for the NGO in Cambodia called the Legal Support for Children and Women, and we work a lot on the cross-border case, especially in the labor trafficking in the fishing industry. I think the non-punishment to the victim is really important, but we need to make sure that it is practiced in all the Asian countries. It is also linked, to all the victim identification. If the process of the victim identification has been done properly by the criminal justice aspect, this will be a good way, to do that. For example, when, we have the case of Cambodian fishermen who escaped from the fishing boat in Indonesia in the, I forgot the Ambon, right? Fine, just escaped from the boat and the Indonesian immigration just arrested. And then because no translation support, no assistance support, the victim, the fisherman cannot testify anything. Finally, you were sent to the jail for 3 or 6 months before they can make to Cambodia. Then the right to claim back all the remedy as a victim of trafficking, you cannot do anything. So when I work on this, I found 2 things that are really important. First, we really need a common victim identification across ASEAN. We really need to develop a common one. We ratify the Palermo Protocol. We have the ASEAN Convention Act. Those are the fundamentals that we can create the victim identification that can be used across ASEAN. For example, if Thailand identify these people as the survivor of human trafficking, and then in Cambodia it had to be done also. But right now, what's the problem? All the return back in Cambodia, we can identify as the victim of trafficking. But again, in Thailand, in the other country, they did not recognize it because they said that this will be based on their jurisdiction. This will be based on their law, national law. So I think it's a little bit challenging that we really need to discuss. So how we make sure that the local law need to be complied with the regional and international framework. That's right now, because every country discuss about their sovereignty, discuss about their jurisdiction. That's why most of the victims of human trafficking become the offender unintentionally. I think even they never commit a crime, but finally, because they cannot prove themselves, no service support, no assistance support, finally become the offender of any crime, for example, of the immigration. So my suggestion maybe we really need to have a common regional victim identification. And I agree with the researcher, we really need to include the non-punishment of the victim into the MOU, bilateral agreement between 2 countries or at the regional level. I think this is something that we really need to do. Yeah, thank you very much.
Thank you very much, Soka. Before asking Marika to react on that wonderful insight from Cambodia, I note that there is an additional recommendation of perhaps a uniform victim identification process in the region, and MOUs as well to include non-punishment. Marika, your reaction, please.
My reaction is Soksha, thank you so much again for all of your insights, both here and in this study previously. I think you raised some really valid points then, and I think you've indeed affirmed one of the findings of this study of the need to harmonize understanding of what trafficking is, so we can be identifying it in common ways. But your comments also emphasized to me the opportunity and the utility of the ASEAN Convention Against Trafficking in Persons. At its heart, that is an instrument that invites us to harmonize our response. So we have a clear path on which to harmonize. And I think you are right to suggest that that should be a key priority. 2 points I would make, though, that I think relate to the earlier comment. Having laws and policies in place don't mean anything unless the individuals who are standing at the front line of their state's response have capacity, have commitments to implement those SOPs or those indicators or whatever they have. Our success in trafficking entirely depends on individual humans and what they choose to do or not to do. So how we address that, I don't know, but I agree with you that having common standards and principles and policies is key. On uniform identification, I agree in principle, but I would raise the caution that the best practice for indicators is that they are constantly updated on the basis of what we know. And so indicators in one context for a particular type of trafficking of a typical type of person may look different from one place to another. That can be within a country or across countries. So I think I agree with you, as long as we are always making sure that with harmonization comes effort to make sure that we are being specific and evidence-based and adaptive to changing challenges.
And being specific and evidence-based is part of why we did this study, Marika, I think, if you can say that. This is a very complex question, and the issue of trafficking breeds a lot of other questions and more complexities. And before we go and be drowned by more complexities, I'd like to recognize one of our participants from Indonesia, I think SBMI, Harry of SBMI, you are recognized. You can unmute your microphone and turn on your video. Thank you.
Ya, terima kasih. Mohon maaf, saya menggunakan berbicara dengan bahasa Indonesia. Terima kasih kepada Dr. Marika yang sudah mempresentasikan temuan yang sangat luar biasa. Tetapi kami di SBMI menemukan sebuah situasi seperti ini kira-kira. Perdagangan orang itu adalah harus melingkupi ada proses, cara, dan tujuan eksploitasi. Dan perdagangan orang ini sebagian besar adalah pelakunya lintas negara. Ada pelaku yang di Indonesia dan juga ada pelaku yang di negara tujuan dalam konteks pekerja migran Indonesia. Kemudian untuk menerapkan 3 unsur itu, proses caranya itu sudah ditemukan di Indonesia, pelaku di Indonesia. Tetapi eksploitasinya adalah dilakukan oleh majikan di negara tujuan. Prakteknya, sebagai contoh beberapa kasus di Singapura, itu sudah teridentifikasi bahwa si A ini adalah korban TPPO menurut Undang-Undang Indonesia. Tetapi faktanya si A ini di Singapura malah dipenjara. Bahkan kemudian pada saat itu adalah divonis hukuman mati. Karena mereka tereksploitasi akhirnya melakukan pembelaan diri. Ini di konteks di ASEAN. Sama juga dengan beberapa fakta di Malaysia seperti itu. Apalagi kemudian kalau kita melihat konteks Timur Tengah. Identifikasi kami bahkan ada pelaku yang di Indonesia juga sudah dituntut di Indonesia, tetapi sampai hari ini korbannya masih menetap di Irak. Tidak bisa kembali ke Indonesia, kemudian juga dilaporkan polisi di Irak sana, kemudian ketika kembali ke Indonesia juga dimintai denda. Hal ini tentulah rumit bagi kami ketika ingin menerapkan bagaimana non-hukuman mati bagi para korban. Nah, saya tertarik dengan apa yang disampaikan oleh Dr. Marika tadi, bagaimana kemudian harapannya temuan ini menjadi standar bersama, menjadi salah satu tools untuk tidak ada diskriminasi di semua negara. Nah, kira-kira strategi dasarnya apa untuk menerapkan ini semua negara, biar pelaku lintas negara ini juga bisa menerapkan, atau semua negara ini bisa menerapkan non-hukuman bagi para korban, baik di Indonesia juga di negara tujuan. Terima kasih, Dr. Marika, itu pertanyaan dari kami.
Thank you so much, Harry of SBMI in Indonesia. And that should encourage, Harry's intervention should encourage other participants that you can speak in local language. And we have the interpretation system in place so that others would be assisted in understanding what your inputs are. Marika, I would now like to invite you to react to that input from Harry, please.
I would love to. Harry, thank you for that. That reminder of the challenges that we face. And I would like to say that I have the answer for you. I don't, but I do have in the next session 26 recommendations about how we can collectively implement the non-punishment principle. I'm sure there are others, and I look forward to hearing from you, but I have some suggestions as to how we can get better at doing this. But I think what I want to emphasize from your comment is, again, this point that we cannot hope to address trafficking within the borders of one country. And your intervention emphasizes too that we cannot fight trafficking in ASEAN only. We have to address it along routes. And doing that requires more than just policies and a recognition of the importance of this principle. Again, it requires us to build relationships with individuals to make sure that we are addressing counterparts in other countries. That is the only answer. And this meeting, of course, is not doing that. This is just for us in this ASEAN region. But when we get to the stage of implementing it, we need to understand, what are your roots of concern? Which counterparts do you need to be engaging with? How can we at ASEAN-ACT or other partners in the region help you achieve those relationships? Because without them, we are abandoning victims, essentially. And so I thank you for making that intervention. It's absolutely valid.
Once again, thanks, Harry, for your intervention, and Marika for your reaction. Marika, I will now go to the chat box and ask for your reactions based on what we have seen in the chat box so far. But Nurul has kindly translated for us the Bahasa inputs here. So according to Marila from Indonesia, there is a threat of additional punishment for trafficking perpetrators who commit criminal acts of trafficking in persons against persons who are still children. Another problem is that victims of child prostitution tend to be placed under a normal adult judicial process in which judges, they don't follow the rules of what is being regulated under the Indonesian juvenile criminal justice system law. Your reaction, Marika?
My reaction is that's extremely concerning, but you've identified the problem, so you know what needs to be addressed, which is an advantage, because in so many challenges we can't identify where the problem is. In that case, you obviously have law in place that can support a stronger response, but you have an implementation and perhaps a capacity issue. And I think that you could strengthen that by drawing on some of the many other guidelines that Cambodia has in place, as we've discussed, that speak to a child-friendly, rights-based approach that would always prioritize the protection of victims above other criminal justice agendas. So I think you have a strong framework in place and a very specific issue to bring that framework to bear to address. Thank you for raising that challenge.
Thank you. Another from the chat box, Marika, says, the principle of non-punishment should be applied to all trafficking victims, including those who were exploited to carry drugs, especially when the victim is a child. Second, when we are assisting victims of trafficking, I think would be a good idea to apply these non-punishment principles, especially to those underaged ones. One thing that often happens is that the document of victims are often falsified. So there is no legal document that can be referenced on the age of the victims, especially children. Thereby, in practice, it is important to always think whether the victim is still to be believed as a child or not only relaying to the legal documentation.
That's excellent. I can only but agree with those comments, Kem. That's my reaction to those, absolutely. And perhaps to emphasize again the best practice principle of the presumption of minority. So when in doubt about whether a person is a child or an adult, the assumption should be that they were a child, so as to reduce the risk of exactly what you're talking about. And of course, that presumption should apply to the time that the alleged offense took place to make sure that they are protected. So even if they're an adult now, if we're talking about what they were, an offense they allegedly commit as a victim of trafficking, that should be our consideration. So I can only but concur with those excellent interventions.
Thank you. Yes, I think this reinforces one of the key findings of this study, especially along the lines of the application of the non-punishment principles relating to children. And now we have a raised hand. Before we go to the raised hand from, who did we have here? I think, yes, from Dina. I'll go first to the inputs from the chat box. So we'll finish the chat box. Marika, what if the trafficking perpetrator is a victim? Can the punishment process of trafficking perpetrators who are actually victims be abolished? Do you have experiences in dealing with such cases in, I think, in other countries? This relates to what you said earlier, that when victims become perpetrators. Your reaction, please.
This is one of the biggest challenges we face in applying the non-punishment principle, because we know how many victims are vulnerable to becoming traffickers themselves. Again, what we said before was that the non-punishment principle should apply to all manner of offense, including trafficking. So the challenge then is on us to figure out whether there is a link between the trafficking and the victim's experience of trafficking and his or her becoming a trafficker. If there is no link, there is no protection. If there is a link, there is protection. And determining that requires the skill of your criminal justice practitioners in a given country, in a given case.
I remember, Marika, in one of the workshops that we have conducted here in the Philippines amongst prosecutors, there was a debate and whether a perpetrator who was formerly a victim should be prosecuted because of the former victimization. But there were some who said that no, because there's no link, as you said, to victimization and being a trafficker this time. I'll now read another intervention from Suka, that there is a need for criminal justice actors to use human rights-based approach to deal or treat with victims of human trafficking rather than use the criminal approach to deal with victims. I think Madam Co-Chair Yuyun will be happy with this insight from Suka. And coming to another intervention from Excellency Chubuneng, she says that Cambodia established the victim identification guideline for services provision. It does mean that we try to identify preliminarily the persons as suspected victims before sending them to court, as the way to respect the victims' rights based on their concerns, traumatized situation, age, gender, and learn that many victims do not receive justice and some have been punished due to the trick or tactic of offenders to make up to be offender and scared to claim their vulnerability. Then, before other steps, we have to investigate, identify them first, and ask them to collaborate with the lawyer and proceed with the legal process. Another from Excellency Chubuning, that what Cambodia has done is to strengthen the identification skills of frontline officials, including to set up child-friendly interview for children victims, as well as to strengthen the referral system to services in order to support victims to survive and encourage them to release trauma and to collaborate with law enforcers and to send the offenders support and not victims. I think, Marika, one of the things I pick up from this insight from Excellency Chubuneng is that there is a connection between non-punishment and a better victim survivor, a witness in court proceedings. May I please ask for your reaction, and then we go to Dina, Marika.
Sorry, Cam, could you just quickly repeat the question?
That there is a connection between a successful, more sustainable victim who becomes a witness for the prosecution when the non-punishment principle is applied.
Oh, absolutely. Without question. And in fact, if the punishment principle is applied, I think we can fairly safely guarantee that that victim will lose all enthusiasm to support the criminal justice process. Because why would a victim feel warmly towards a system that has criminalized him or her when he is not treated as an ally? So an emphatic yes, Kem.
Yep, and this must encourage states to observe the non-punishment principles in trafficking in persons cases, given so that we can prosecute traffickers. Now we go to Dina. Dina will be our final reactor or commenter or the question for this part of the workshop. And then after Dina, we go into a break. Dina, please go ahead.
Okay, thank you for the opportunity. Thank you, Marika, for the enlightening research for the non-punishment principles. It's very interesting. My question is, actually, I work as a staff for Ministry of Women Empowerment and Child Protection in Indonesia. So my work doesn't involve directly in the law enforcement process, but my work mostly consists of coordinating and facilitating institutions. And for one of those many meetings with the law enforcement, I heard that there were some cases in Indonesia where victims refused to be identified as victims. And I'm just curious if these challenges to identify victims came up in this research, and what can they do to overcome this challenge? Thank you.
Thank you, Dina, for raising that, and thank you for the important work that you do on counter trafficking. Yes, that did come up. I think that issue always comes up when we're researching anything to do with victims' rights. And that issue is not one that is exclusive to Indonesia. In many countries in ASEAN and outside of ASEAN, victims don't want to be identified because they don't stand to benefit. And in fact, sometimes victims' lives may get worse if they're made to participate in criminal justice proceedings, if they're stigmatized, and indeed, if they're punished by criminal justice systems. So there's a lot there for us to learn, and we need to be asking ourselves very frank and honest questions about our victim protection services and approaches if victims don't want anything to do with them. Some of the concern may be because they don't understand that they will benefit from the system, and that can relate to insufficient communication with victims. Are we explaining victims their rights in ways that they understand? Are we making sure that we don't overpromise? Are we being honest with victims? Are we telling them the reality of what will happen in the identification and protection process? So I think there's a lot of levels that we can try to unpack that challenge, but you are certainly not alone in facing that challenge. And I think it's something of a wake-up call to us when we encounter that issue. We need to learn from victims what are their reservations about identification, and then address them one by one.
Thank you, Dina and Marika. There is another question in the chat box, Nadia from the AGC in Malaysia. I promised to ask Marika that question, Nadia, but for now, other participants are raring to go into a lunch break. But yes, Marika, you raised your hand.
No, I do want to, I'm glad Nadia raised this, because I think it's a good one to end on, Kem, because we've spoken a lot about victim rights, and the question that Nadia is asking is how we maintain a balance between victims' rights, presumably to be not punished, but also the state's national interest and security, and the state's interest indeed to prosecute offenders of crimes. And that is an extremely good question. The two issues are not in contradiction with each other. The protection of punishment of victims is not a blanket provision. If I am a victim of trafficking, I can't go out and commit any crime I want and not face justice for it. What we are trying to do is make sure that we are not punishing victims for those offenses that they commit, where they are not free agents because they are victims. And that there is part of our national security interests. It's in service, as you just said, Sir Kem, it's in service of strengthening our response to transnational organized crime. So those two agendas are not in any conflict through the non-punishment principle. Indeed, they are serviced by them. So that's a note I wanted to end on, and I thank Nadia for raising that excellent question.
Yes, thank you so much, Nadia, and of course, Dr. Marika, for your reaction to the questions of other participants. Dear participants, we're just in the middle of these discussions. Keep your comments, insights, questions in validation of in view of the key findings of the workshop. And in the next one, after the break, we're going to go into the recommendations. So please continue to type in your insights into the chat box, or if you have questions for our author. And at this point, I would like to acknowledge the presence of our keynote address speaker, UN Special Rapporteur on Trafficking in Persons, Professor Siobhán Mullally has just joined us from Ireland, I think. Good morning to you, Professor Siobhán.
Good morning, thank you. Good morning, all.
Yes, thank you, Professor Siobhán, and later on we'll be hearing from Professor Siobhán. And now, I have the honor of asking Honorable Co-Chair ASEC Morales for a 5-minute break. Assistant Secretary Morales, please.
Okay, yeah, thank you, Director Kem. Your request for 5-minute break is approved.
Thank you so much, Co-Chair. May we please ask our colleagues to please, yes, the 5-minute timer. It's now a break, ladies and gentlemen, excellencies. Let's resume the session after 5 minutes.
Yeah, take a
Welcome back, Excellencies, ladies and gentlemen, and dear participants. Honorable Co-Chair Morales, may we now resume the session, please?
This meeting is hereby resumed.
Thank you so much, Assistant Secretary Morales. Now we have Marika presented to us the key findings of the study, and we talk about the key findings, your reactions, some insights also from you, additional inputs, and even questions, and also raising some earlier recommendations coming from the different participants who provided their interventions. At this time, we would like to invite once more the author of the study, Dr. Marika McAdam, to give us the recommendations part of this paper. Marika, you're recognized and you have the floor. Please proceed.
Thank you kindly, Cam. That 5 minutes went very quickly. You all provided such rich feedback. And I note also that many of your inputs already went to the section of recommendations. And you indeed affirmed one of my findings of this study, and that is that there is enormous interest in the ASEAN region to strengthen efforts on this principle. And that's come out again so clearly in your responses to this presentation of findings. And so now to turn to the recommendations. Now, in an ideal world, of course, there would only be one recommendation, and that would be to ensure that victims of trafficking who commit offences as a consequence of being trafficked are never punished for those offences. However, we don't live in an ideal world. And so what I have attempted to do is offer a series of recommendations, not just at the outset, at the point of identification, but throughout the criminal justice process. So the first set of recommendations, and again, you received these in your executive summary. Obviously, we need to build capacity to identify victims of trafficking. This came out strongly in our discussion. That includes the need to strengthen understanding of law enforcement, of control methods used by traffickers and their impacts on victims. That may, of course, help them to understand why a person in front of them may have committed a crime, because it may not be obvious that an offender is a victim. So they have to look behind that. Part of looking behind what's really going on is to challenge misconceptions and assumptions that we have about ideal or deserving victims of trafficking. Now, around the world, not just in the ASEAN region, but more generally, criminal justice practitioners may have views about certain victims, and their understanding of those may impact and detract from their ability to identify them. In the ASEAN region, happily, it was agreed by everyone that sexuality is of no issue. So people regardless of whether they're gay or straight or transgender, this was no impediment. But issues were raised around questions of gender and sex, and around type of work. And the concern was raised, for instance, that people in certain types of work, for instance, in the sex industry, or people who were doing irregular work may be stigmatized. And so investigators may not be able to recognize victims of trafficking among those who they identify as offenders. So that's key to strengthen identification and investigation, to emphasize that the principle applies to all victims where there is a nexus between the offending or the trafficking. It doesn't matter who the victim is. And a final recommendation on this point is to proactively investigate the links between the offense of that victim offender and the conduct of potential traffickers. Because here, of course, we have a challenge. The offender in front of us, who is a victim, may not necessarily point to a situation of trafficking in the background unless we proactively look at it. But that requires time, skill, and a great deal of effort. So how do we incentivize investigators to commit that time, skill, and effort to find the traffickers behind the offenders who we may encounter in practice? Now, again, ideally, victims of trafficking won't be arrested, but in the event that they are, we can perhaps mitigate some risk of punishment to them by ensuring that frontline officers understand the impacts of arrest on victims of trafficking and criminal justice responses to trafficking. Where, and Kem, we just discussed this, where victims are treated like offenders, they are less likely to cooperate. They are less likely to give us information about what has happened to them. And that means that our ability to identify the serious organized crime of trafficking is impeded. We have to be upholding the rights of people we arrest so we can remedy any arrests that shouldn't have been made. Part of this requires frontline officers to understand what discretions they have to arrest or not arrest, and different jurisdictions it may be different. In some cases they may have to arrest a person who commits a crime. In other jurisdictions, perhaps investigators can say, no, I understand the person has committed a crime, but I understand why, so I will not arrest this person who I know to be a victim of trafficking. So it's important to understand in our jurisdictions what the opportunities are here. And again, we need to ask, how do we incentivize law enforcers to apply the non-punishment principle? Because a key challenge that we briefly discussed before, where performance may be measured by the arrests that they carry out rather than the absence of arrest, how do we address that problem? How do we potentially, rather than rewarding frontline officers for arresting people, how do we reward them for exercising their judgment to refer a person they encounter? How can we build this into our criminal justice response? And the final recommendation here is to make sure that arresting officers understand what their obligations are to arrested persons, to make sure that they are upholding a human rights-based approach in their arrest, because we know that rights-based approaches to arrest are absolutely key to rights-based approaches to counter trafficking. And of course, I made a note here to say that irrespective of whether they have discretion or not, it's crucial that they are gathering all possible evidence, because that will be key to both the prosecution of traffickers, but also to the defense of victims who may unfortunately find themselves on trial. And again, we're talking here about last resort, because at the point they are arrested, they are already being punished. And this is the very scenario we are trying to avoid. So let me keep on repeating that. And I'm sure Professor Mullally will also make that point. On prosecution, opportunities here to amend legislation to strengthen our ability to uphold the principle. That may look like a few different things. For instance, some jurisdictions may find it useful to capture explicitly in their trafficking definition that exploitation can include exploitation in criminal activity. That may be useful for practitioners to be able to see and apply this definition to the situations that they encounter. It may also mean checking again the non-punishment provision. Is it fit for purpose? Is it framed in a way that's useful and is easy to apply and accessible for practitioners? And it can also look like addressing vacateur laws, opportunities to remove criminal records. It may even require amendments to other areas of the law, whether it's drug offences that we may need to cross-link to trafficking, or indeed offences in the sex industry that may have detrimental impact and result in punishment of victims. So it depends on what is happening in a given country, but I think there is a lot to be considered there. Also, it's key, of course, to make sure that any decision to prosecute a victim only happens after a formal identification process has been made. And I think we had that discussion already in the previous session. Important too, for states to clarify what the relationship is between victim status and non-prosecution. And this came up in the research. When a person is positively identified as being a victim of trafficking, what does that mean for their prosecution or their not prosecution? And what are the circumstances that determine what will happen next? Again, those questions need to be answered. Prosecutors need to understand what their discretions are to stop the prosecution if they realize that they may be prosecuting a person who should not be prosecuted. What discretions do they have, and how do they apply them? Number 14, provide training to prosecutors. And again, we in the counter-trafficking community continually train counter-trafficking actors. We need to do that, of course, but in the context of non-punishment, we also need to be training people outside of the trafficking world. We need to be training, for instance, prosecutors who prosecute drug-related offenses, because they may not know that they are actually prosecuting victims of trafficking. So this is a key challenge for us. We need to branch out and broaden what we do. And one of my favorite issues, only because it's one I encounter so often, is the irrelevance of consent. This continues to play a really challenging role in the response and the understanding of trafficking in persons. And it has an impact, of course, in the non-punishment principle. So the training needs to be really specific and needs to, of course, make sure that prosecutors are only prosecuting people who have the requisite criminal intent. And that criminal intent must not have been damaged by means used. So again, it's about bringing all these understandings together to make sure that the non-punishment principle is upheld. Defenses, and again, one of our failings in the counter-trafficking community, we speak so much about prosecution and less about defenses. But when it comes to defending victims of trafficking who may be on trial for offenses that they have commit, we need to make sure that our legislation, and indeed our guidance, where we have no specific legislation, makes sure that the non-punishment principle applies to all victims. So not only women and children, it applies to all offenses, so not only prostitution and immigration. And we need to be clear too on how the link is established between the victim's offending and his or her trafficking, and put that understanding into the hands of practitioners. And to the next point then, that means making sure that practitioners understand, is the model one of compulsion? Is the model one of causation, or is there another model, and how do I apply it? And importantly too, where the model is compulsion, where we're saying that the non-punishment principle applies because the victim was compelled to commit an offense, we have to make sure that that understanding aligns with our understanding of trafficking in persons that can involve a range of means, not just physical force, but things like abuse of a position of vulnerability. Our understanding has to capture all of that broadly. Also, we need to provide, need to ensure that the burden of proof rests on the state. So it should be for the state to explain why the defense does not apply. So we're not placing undue burdens on victims. And point number 20, and this relates very much to the last question or the last comment that was raised in the previous session. How do we guard against the misuse of the non-punishment principle? Again, this is not blanket immunity. This is not an opportunity to escape justice for offenses committed. How we guard against the misuse of this principle is by making sure that practitioners are skillfully and faithfully applying the trafficking in persons law in identifying the 3-element test of trafficking, or indeed 2 in the case of children, who, as we know, we don't need to prove the means for. So a faithful application of the law is what guards against the misuse. In conviction and sentencing, And again, I have to keep on stressing, here we are talking about last resorts, because victims of trafficking should not be convicted or sentenced for offences that they commit as a consequence of being trafficked. But we have to minimise harm. So to address that, members of the judiciary play a key role here, and ideally should be empowered to raise the non-punishment principle, even where that principle has not been raised by the defense or the prosecution. So judges need to be sensitized to the non-punishment principle and understand their role in it. Now, in some jurisdictions, they may be able to mitigate sentences or not sentence a person at all. So we need to understand in our countries, what are the options that judges have and how do we support them to understand those options and to apply it. And of course, as a rule of thumb, sentences for any offence should reflect the degree of culpability. So in the case of trafficking victims who commit offence, the stronger the nexus between their offending and their trafficking, the less culpable they should be considered to be. 23 is, of course, consider restorative justice rather than retributive justice for victim offenders. You know, is conviction and incarceration our only option? Is it really working? If not, why not? What are other countries doing that seek to address these issues of offending, and how can we maybe apply them in our jurisdictions? And of course, number 24 relates to corporal and capital punishment. And these issues did come up. And the very real risk that victims of trafficking are facing corporal or capital punishment, I think impresses upon us just how urgent this issue is. And these, of course, raise human rights issues for all of us. But of course, these risks, as we discussed, can deter victims from seeking support. Victims may not want to come forward to authorities because they fear that they've commit crimes and that the authorities won't understand why they commit those crimes. And so they may face these very serious punishments. How do we address that barrier, which is a barrier not only to victim protection, but is also a barrier to our capacity to fulfill our obligations to confront counter trafficking? And as a practical consideration as well, where death penalty is imposed or capital punishment, it raises challenges for cooperation from different parties. And above all, and this is not unfortunately a hypothetical question, but a very real one, where the death penalty is imposed, states have to be clear on whether the non-punishment principle was applied if the person on trial was a victim of trafficking, and why it hasn't been applied if it hasn't managed to protect a potential victim from punishment. And just finally, two recommendations on post-conviction. So in the unfortunate event that we haven't managed to protect a victim across any of these points of the criminal justice process, so a victim has unfortunately been unjustly prosecuted and convicted, what can we do? Well, I think we can explore opportunities that may exist in the legislation to set aside criminal records. And here there's significant evidence that shows that victims of trafficking who've been criminalized and have criminal records, even for really minor offenses, that can have such long-term ramifications for them. It can delay their recovery, it can delay their reintegration, it can deny them opportunities for employment, for education, for accommodation. It can even have impact on child custody. So these are very serious, essentially, forms of punishment that we have an opportunity potentially to address here. And if we don't, we need to identify why. What are the barriers to setting aside criminal records of a victim who has been unjustly convicted? So again, a lot of the recommendations call on us to familiarize ourselves with the opportunities that exist in our domestic system to apply the non-punishment principle, and then to calibrate our systems in order to achieve it to its full potential. That brings me to the end of my presentation on this, and so I will turn to Kem to champion the discussion here. What we want to know from you here are, do you have any additional recommendations that you think we should capture in this report? And secondly, and I think extremely importantly for my colleagues at ASEAN-ACT, how can ASEAN-ACT support you to disseminate these recommendations and to implement them? Because, and someone I think already raised this question, how do we turn these all these words into action? And it's very clear to me from among all of you that there is a great deal of enthusiasm to do just that. So how can we help you? On that note, Kem, I hand back to you and welcome feedback. Thank you.
Thank you so much, Marika. I do not envy the fun yet cerebral process in which you have undergone into coming up with all these recommendations. The lot of them, 24. So, and I think our participants also appreciate the depth of your recommendations here. So we now turn to our participants now in asking the questions. Any additions or clarifications that you wish to put forward, any additional recommendations, your clarification on the recommendations, also on what are your suggestions on how ASEAN-ACT can support states in the dissemination and implementation of the findings and the recommendations in this study. So once again, I would like to encourage our participants, you can turn on your microphone, unmute yourself, and then turn on your video as well and provide us your inputs, or you can go to the chat box for your inputs as well. You may speak in your national language. So far, we have heard from participants from Indonesia, Malaysia, Philippines, and Cambodia. We would love to hear from other countries as well. You are free to provide us your additional recommendations. You're thinking about the recommendations which Marika have just shared with us. So we'll be monitoring once again your comments in the chat box and even your questions. And at this point, I think any additional recommendations or clarification to the recommendations. And while you are thinking about what you wish to say, what you wish to add, or your intervention, we'd encourage for you to once again have a look at the chat box there. We have the link to the attendance sheet. Kindly fill out the form so that we can share with you your certificates of participation in this wonderful workshop, I would say, Marika. And now I see that Madam Co-Chair, Excellency Yuyun Wahyuningrum has raised her hand, and we recognize Excellency Yuyun, please.
Thank you so much, Kem. Thank you so much, Marika, for the recommendations. As mentioned earlier, I expected to hear some recommendation for AICHR to do. But before that, I would also like to mention that one of the recommendations that participants mentioned during the last training on the human rights-based approach to trafficking in person, we just finished in November. One of them is to ASEAN member state to consider not holding victims of trafficking in person criminally or administratively liable for unlawfully act committed by them, and take necessary protective operational measures of assistance and protection. This is something that AICHR Indonesia would like to follow up in different forms. I think learning in ASEAN, we don't have, even though it is looking at the non-punishment for non-punishment principle for trafficking in person, but is also applicable to other issues like you mentioned about death penalty and others. That is not only this recommendation from the participants going to be in follow up through the series of activities in relation to trafficking in person, but also in relation to other articles in the ASEAN Human Rights Declaration. So for instance, the right to remedy. At the moment, I mentioned earlier, one of the role of AICHR is to come up with the regional norms and regional standards, aiming at helping member state and also helping the ASEAN member state, ASEAN sectoral bodies to develop like some kind of guidance or ways to help them how to implement their project based on human rights-based approach. So we are looking at efforts or measures or initiative to provide interpretation of the ASEAN Human Rights Declaration, articles in ASEAN Human Rights Declaration. So what you have been mentioning through your research fit with many things in ASEAN Human Rights Declaration. So I would like to encourage you to look at it and perhaps identify what AICHR should do. In relation to trafficking, Article 13 in ASEAN Human Rights Declaration mentioned about it. The right of women and children mentioned very clearly in the Article 4. So we have been using this ASEAN Human Rights Declaration as an entry point because this is the base of our regional cooperation in ASEAN in relation to human rights. So it comes across at different issues. And since trafficking in person has a specific work plan led by SOMTC, so we align ourselves to them. But I would like to add here first, maybe some recommendation can be, I appreciate this recommendation is very technical and very detailed. I think this can be implemented immediately without further translation or interpretation to certain meaning, but may also consider to make a recommendation on what ASEAN sectoral bodies can do or should do to realize the non-punishment principle in their own capacity, in their own mandate. So in the case of AICHR, I would like to encourage to look at our guidance of work like ASEAN Human Rights Declaration and also the term of reference of AICHR, which very much linked to many of this. Thank you very much.
Thank you so much, Ibu Yuyun. I'll give the floor to Marika to react to those excellent intervention from Ibu Yuyun.
Indeed, Ibu Yuyun, I'd like to react very enthusiastically. I think for my part, and certainly I could say on behalf of ASEAN-ACT, we're thrilled to find a partner in AICHR on this. And to the extent that I can increase reference to human rights declarations and specific points of intersection, I will absolutely do that. And there is indeed scope to do so. As you pointed out, a lot of these recommendations are very technical. In the full study, there's more commentary to explain them a bit better. And I think there will really be scope for that. But otherwise, let us look forward to sitting down together again and talking really specifically about how we can institutionally move forward on this issue. Because as you rightly point out, a human rights-based approach is critical to this. And this is, of course, critical to a human rights-based approach. So we need to really interrelate them in order to move forward on this. And so I am delighted to hear your enthusiasm to do so. And thank you very much for those references, which I've noted.
Thank you, Marika and Ibu Yuyun. And one comment from our DFI partners. Thanks, Dr. Marika, for the presentation. The findings and recommendations are very meaningful and useful. I urge ASEAN-ACT to support translation of these findings and recommendations into national languages, then support on developing the non-punishment principle for Lao, then training and raise awareness of the principles. Many thanks again. I think that answers the questions of any suggestions on how ASEAN-ACT can support states in the dissemination and sensitization towards non-punishment principle in ASEAN. And we thank DFI Conseng for the very important remark. Yes, any other thoughts from our dear participants? We now have, we've heard from Lao PDR as well. Perhaps potentially, I think we could invite our participants from Thailand. I'm sure that Prosecutor Sugunya, Excellency Sugunya, if you have some ideas about the recommendations, and if you're ready to share them at this point. Also, we have from MSDHS Thailand, Konrachapon is also with us. Please, if you are ready and you have your ideas to share to the workshop, we would be happy to entertain them. And in addition to that, I think we now have sufficient amount of information coming out of this workshop. And many of the things have been duly noted by our author, Dr. Marika. And the richness of the discussions would really improve the findings of the study and the recommendations in the study. So once again, I call on other participants to provide your comments about the recommendations. And if you have, I see, Marika, that you have been extensive in your recommendations, some reactive recommendations. Also, in systems thinking, you have the feedback, reinforcing, and balancing loops, I think, in check. So that was an excellent one. And now we have Prosecutor. Yes, Prosecutor, you're recognized. Go ahead, please.
ดิฉันสุกัญญารัตนนาคินอัยการพิเศษฝ่ายสำนักงานคดีค้ามนุษย์นะคะดิฉันอยากจะสอบถามเกี่ยวกับเรื่องสิทธิของผู้เสียหายที่อยู่ในสถานคุ้มครองนะคะที่มีการกล่าวถึงกันว่าจะต้องมีเสรีภาพมีอิสระในการที่จะใช้โทรศัพท์ในการที่จะติดต่อได้ซึ่งมันจะมีเส้นขีดแบ่งกันระหว่างการที่ผู้เสียหายยังไม่เข้าใจว่าตัวเองเป็นผู้เสียหายแล้วก็พยายามที่จะเรียกว่าอาจจะปกปิดข้อมูลหรือว่ายังไม่พร้อมที่จะให้การหรือว่ายังอยากจะช่วยกลุ่มผู้กระทำความผิดซึ่งผู้เสียหายเข้าใจว่าเป็นผู้ที่มีบุญคุณกับตนเพราะฉะนั้นการที่ผู้เสียหายต้องไปเข้าสู่สถานโปรแกรมที่จะต้องคุ้มครองสิทธิของผู้เสียหายหรืออาจจะเป็นผู้เสียหายในคดีค้ามนุษย์ตรงนี้นะคะซึ่งมันจะมีลักษณะของการที่ว่าห้ามใช้โทรศัพท์ในระหว่างที่มีการอยู่ในสถานคุ้มครองเพื่อที่จะไม่ให้กลุ่มผู้กระทำความผิดเข้ามาครอบงำผู้เสียหายหรือว่าชักจูงอะไรเงี้ยค่ะมันจึงเกิดเป็นประเด็นเป็นปัญหาว่าในกรณีเหล่านี้เนี่ยเป็นการละเมิดสิทธิมนุษยชนของผู้เสียหายหรือเปล่าเพราะว่าดิฉันเคยไปดูงานที่ประเทศสหรัฐอเมริกาแล้วก็มีคดีที่ผู้เสียหายในคดีค้ามนุษย์ซึ่งมีทั้งคนไทยเป็นผู้เสียหายแล้วก็ผู้กระทำความผิดเป็นคนไทยซึ่งเราก็อยากที่จะติดต่อกับผู้เสียหายที่เหตุเกิดขึ้นตรงนั้นน่ะเขาก็ไม่ได้ให้เราติดต่อเขาก็อธิบายว่าจนกว่าผู้เสียหายจะได้ขึ้นศาลเสร็จเรียบร้อยแล้วมันก็เลยเป็นประเด็นมาสู่คำถามที่ดิฉันสงสัยมาตลอดมาว่าถ้าเกิดว่าในกรณีที่ผู้เสียหายอยู่ในสถานคุ้มครองแล้วจะต้องมีการจำกัดในเรื่องของการใช้โทรศัพท์ติดต่อตรงนี้นะคะจะมีเสรีภาพมากน้อยอิสระมากน้อยแค่ไหนที่จะไม่เป็นการละเมิดสิทธิของผู้เสียหายหรือว่าเป็นการที่ทำให้กลุ่มผู้กระทำความผิดเข้ามาล็อบบี้หรือเข้ามาครอบงำผู้เสียหายได้นะคะก็อยากจะทราบในประเด็นนี้ค่ะ
Thank you so much, Prosecutor Sugunya. I'll go to Marika to give her reaction, please.
Thank you, Prosecutor, for raising this issue. Indeed, shelter practices raise a great deal of challenges to balance our objectives to bring traffickers to justice, along with our obligation to uphold the rights of victims. On the question of liberty and freedom, victims of trafficking, of course, have the same liberties and freedoms as other humans, of course, with some complex considerations tied in there. But as it relates to the non-punishment principle, of course, there are certain situations where victims shouldn't be in shelters at all, because in some situations that would constitute a form of punishment. And in other situations, it may be valid and indeed necessary to uphold and protect their rights. And on this, ASEAN-ACT has also conducted a study about issues of freedom of movement and sheltering of victims. And we can share that with you either in the chat or after the workshop. We're happy to send you the link to that study.
Thank you so much, Dr. Marika and Prosecutor Sugunya from Thailand. In the interest of time, Excellencies, ladies and gentlemen, Mr. Chair, allow me to proceed with the next item in the agenda. But before going there, we would like to remind our participants to kindly fill in once again another reminder, the registration form, the attendance sheet, and also we'd encourage to hear from you more after this workshop. You'll have until the 16th of December to provide us your questions, your recommendations, some more, and to answer the questions. If you have anything to add, clarify on the presentations of the key findings and the recommendations, if you have additional comments, and also if you have additional questions, how ASEAN-ACT can support the dissemination of the key findings and the recommendations of the study. And at this point, I would like to encourage our participants, if you have questions after this workshop, please feel free to send them to us, to the emails that have communicated with you in the preparation to this workshop. Any comments would be helpful to make this study richer and fuller, if I may say. Excellencies, ladies and gentlemen, Mr. Co-Chair, may we now please proceed to the next item in the agenda?
Yes, Director Kem, you may proceed to the next item.
Thank you so much. Ladies and gentlemen, Excellencies, it is my honor to invite to the floor to deliver the keynote speech from the United Nations Special Rapporteur on Trafficking in Persons, especially women and children, on the application of the non-punishment principles to advanced states. May I please invite Professor Siobhán Mullally, the UN Special Rapporteur on Trafficking in Persons, especially women and children. Professor Siobhán, you have the floor.
Good morning, good afternoon. Thank you very much for this opportunity to join this important workshop and to mark the launch of this report. And I want to thank the organizers for the invitation to participate and to congratulate Dr. Marika McAdam and all those who were involved in the consultations and preparation of the report. And I would like to say at the outset that I consider this report to be hugely important in terms of the development of our legal analysis of the difficulties in implementing and ensuring effective application of the principle of non-punishment in international law. So thank you very much to ASEAN-ACT and to SOMTC Philippines for convening this event and for the opportunity to speak at the launch of the study. The principle of non-punishment was the subject of my report to the UN Human Rights Council earlier this year, presented in June. And prior to that, we had a series of workshops and discussions, and Dr. McAdam contributed to those workshops and to those discussions and played a really important part in providing commentary and input on the report to the Human Rights Council. So I'm particularly grateful that this report examines the challenges around implementation and application of the principle in the ASEAN region, and is so comprehensive in pointing to the specific challenges that arise in practice and the recommendations which inform practitioners, policymakers, and legislators, all of the actors that are critical in ensuring a more effective application of the principle. What I would say is that the principle of non-punishment of victims of trafficking is really core. It's critical to the human rights-based approach to combating human trafficking. And that is a phrase or a term that we tend to use very easily, somewhat flippantly at times, the human rights-based approach, the human rights-based response to human trafficking. But we really are at the point where we need to tackle in detail what this means, what it means to prioritize and foreground a human rights-based approach and response. And here, non-punishment of victims poses a challenge to states and to all justice sector actors, because, as was noted in the report and Marika's presentation, the impulse is for those investigating and prosecuting crimes to try to ensure that there is an effective investigation and prosecution. And where the person who is accused may be a victim of trafficking, it can be difficult to distinguish and make an assessment that the non-punishment principle must be applied. And that is critical to the rule of law and critical to a human rights-based approach to responding to trafficking in persons. And what this report highlights, and what we also highlighted in the report to the Human Rights Council, is that the principle of non-punishment is very much contested in international law and in legal responses to human trafficking. Its scope is often challenged. Which offences does it apply to? Which unlawful acts does it apply to? Does it apply to serious criminal offences? And at what stage should it be applied? So although we see recognition of the principle, we see its adoption in domestic law across the globe and in regional instruments, we still see that in practice, in legislation, there are often exceptions, and in the practice, in its implementation, its scope is often challenged. So this is something that we need to be aware of, and we need to highlight. The principle of non-punishment in international law should apply regardless of the gravity of the offence. And it should be applied as early as possible to ensure effective protection of the human rights of victims. And I use the term unlawful acts quite deliberately, because as is highlighted here in this study also, the range of forms of punishment can vary greatly. And we need to ensure that the principle of non-punishment captures a full range of unlawful acts that a victim of trafficking might be punished for, subject to administrative sanctions or civil sanctions or criminal sanctions. So recognizing the diversity of legal systems and recognizing the range of different forms of sanctions that may be applied with regard to different types of acts. So it could be immigration or status related unlawful acts, or it could be criminal offenses. And we also need to recognize that in some jurisdictions, engaging in sex work or prostitution may also attract penalties. And there again, we need to ensure that the non-punishment principle is applied if we are to be serious about prioritizing the human rights of victims on a basis of non-discrimination on grounds of migration status, race or ethnicity, age or gender, or disability, for example. And as Marika highlighted in her presentations and in the report itself, and as many of the commentators and questions have brought to our attention also, the principle of non-punishment is critically linked to effective identification processes and measures. To ensure application of the principle of non-punishment, we must ensure that victims are identified as such and identified as early as possible to avoid being subject to prosecution or to other forms of punishment. So early identification is really critical, and legal assistance and the provision of legal assistance throughout identification procedures is critical. We need to ensure that all relevant actors are trained to enable identification at border crossings, in healthcare centres, by social services, by child protection specialists, all of those who may come into contact with victims of trafficking, because that early identification and referral for protection can ensure that we avoid a situation where victims are being punished for unlawful acts that are committed as a direct consequence of being trafficked. And we also need to ensure that in implementing the principle of non-punishment and in our identification procedures, in our assistance and protection procedures, that we ensure that all measures are disability inclusive, so that we comply with the obligations under the Convention on the Rights of Persons with Disabilities and under international human rights law to ensure access to justice for trafficked persons with disabilities, using the human rights model of the Disability Convention. So recognizing psychosocial and intellectual disabilities as well as physical disabilities. And I note this because we know that disability may hinder a person from being identified and may also hinder the application of the non-punishment principle. So a victim of trafficking with an intellectual disability, for example, may be punished for an unlawful act where in fact they should have been recognized as a victim of trafficking. And that requires ensuring that we have appropriate procedures in place to ensure non-discrimination and reasonable accommodation. And I just want to reference an important recent judgment of the European Court of Human Rights on non-punishment, AN and VCL versus the United Kingdom. This was a really important judgment which involved two Vietnamese boys, adolescent boys, who were trafficked to the UK for the purposes of forced criminality, cannabis cultivation in this case. And the case was a tragic one in that the boys initially were not identified as victims of trafficking, but even later when they were identified, a decision was taken to continue with the prosecution for the drug-related offences. And as was mentioned earlier, often victims of trafficking are engaged in drug-related offences, the purpose of forced criminality being the relevant one here. And here, the European Court of Human Rights, it was the first time that the court looked at the non-punishment principle, said that this was an important component of a state's positive obligations of assistance to victims of trafficking, arising under the European Convention on Human Rights, the prohibition on slavery, servitude and forced or compulsory labor, which we also find, of course, in the ASEAN Declaration and in international human rights instruments. And here the court emphasized that punishment would be injurious to a victim's recovery and was contrary to obligations of protection. And very important also, the court found that the non-punishment principle was integrally linked to the right to a fair trial, which is protected in Article 6 of the European Convention on Human Rights, but also, of course, found in Article 20 of the ASEAN Declaration and in multiple international and regional human rights instruments. So that was really important, also recognizing that the right to a fair trial itself is impeded if we do not recognize and implement the non-punishment principle in a timely way and in an effective manner. And I also just want to mention the Global Compact on Migration, Objective 10 of which commits us to eradicating trafficking in persons, and specifically includes a commitment to ensuring safe reporting for victims of trafficking without a fear of being punished for unlawful acts. So that possibility of safe reporting is critical there also, and included within the Global Compact on Migration. We have just had the regional reviews, and I was able to participate in the Asia Pacific regional review, and we will be coming up to the 2022 review in May, June this year. And again, I think this is really important that we bring to the fore in that review process and any outcome documents, the principle of non-punishment as a core element of the human rights-based approach to combating trafficking. It's also relevant to the asylum context and to the right to seek and enjoy asylum. Article 31 of the 1951 Refugee Convention relates to non-penalization of asylum seekers on the basis, for example, of illegal entry. And there again, this is relevant also to victims of trafficking who are seeking asylum, as is their right. So we find this principle in many legal instruments, but as Marika and as the study has highlighted, it's the implementation and practice that is often problematic. And I think it was very welcome to hear from AICHR the willingness to cooperate further and to look at what guidelines might be developed, what practice guidance could be rolled out to ensure more effective implementation on the ground. And in my capacity as Special Rapporteur, I have been very pleased to have the opportunity to engage with AICHR and also with the ASEAN Commission on the status of women. And I think this cooperation will be essential to ensuring more effective implementation and understanding of the non-punishment principle. A point that was mentioned in the recommendations and in the study is the point around post-conviction remedies. And I think this is hugely important also. Ideally, we want to ensure that the non-punishment principle is applied as early as possible. However, if we are in a situation where there has been a conviction wrongfully of a victim of trafficking, we need to ensure that there are accessible procedures to expunge criminal records, to eliminate criminal records. Because without that, a victim of trafficking is hindered in being able to achieve a full recovery, long-term social inclusion, in accessing employment and possibly educational or professional qualifications. And this is something we see in many jurisdictions, the way in which criminal records or administrative sanctions such as fines continue to hinder the possibility of a victim of trafficking making a full recovery, being able to access employment and to move on to a new life. And here it's really important also that legal aid and legal assistance is provided at those stages to enable effective access to post-conviction remedies, and ensuring also that this is accessible for children and young people in a child-friendly justice way, and that it is, of course, disability inclusive, in line with the CRPD's provisions on access to justice, access to effective remedies, and their general comments on that. And more broadly, I think we really need to look at how the non-punishment principle is implemented with regard to children and young people to ensure that it is fully integrated into all of our guidance and practice on youth justice and child-friendly justice, because we have several legal instruments, policy documents and guidance that we can draw on. But often trafficking is seen as such a specialized issue. It's not always fully integrated into these broader child protection, juvenile justice, youth justice and human rights law instruments. So we really need to mainstream it into those wider discussions. Looking also at international legal instruments and obligations arising with regard to children who may be recruited into armed conflict, for example, by armed groups, and should be recognized under international law as victims of grave violations of human rights and international humanitarian law, but are often not identified and recognized as such. And that, of course, leads to failures of protection. And to conclude again, I just want to return to two notes that we discussed last week and that were highlighted last week at the UN General Assembly, the high-level meeting on the Global Plan of Action on Trafficking in Persons. And through a lot of coordinated work and advocacy, we ensured that the outcome document, the political declaration, again includes a commitment to non-punishment and to the human rights-based approach. And a point that was made by survivors of human trafficking speaking at the event was the importance of moving beyond stereotypes as to who is a victim of trafficking. That we don't look for the ideal type victim or perfect victim, that we apply the principle of non-discrimination, a core principle of international human rights law, and that is essential to ensuring that victims of trafficking are recognized and are identified at border crossings in all sectors, that we move beyond those stereotypes. And that we do that on the basis of gender equality also, as was mentioned repeatedly here and in the study. Different forms of so-called protection mechanisms, closed shelters, for example, restrictions on movement, these may amount to forms of deprivation of liberty and forms of punishment, and are contrary to this human rights-based approach and to a commitment to gender equality, as it is often women and girls in particular that are presumed to be in need of such protection. So recognizing the autonomy, the dignity, the human rights of victims of trafficking is critical on a basis of non-discrimination. So thank you very much to Marika. Congratulations again to all involved on the work on this study and the launch. And I look forward to working with you in any way that I can through my mandate to progress this work further. Thank you.
Thank you so much, Professor Siobhán Mullally. Apologies, we were out of connection for a moment. There had been a slight connection problem in our area, but yes, thank you so much for your address. And at this point, I would like to take this opportunity to ask our co-chairs to give a quick response to your address, Professor Siobhán. The co-chair, Assistant Secretary Morales, is recognized.
Thank you, Professor Siobhán Mullally, for the comprehensive and valuable message. In adherence to Active Article 14, Section 7, we underscored the importance of the non-punishment as a compulsory and critical tool to uphold victims' protection. As the TIP become interdisciplinary in nature, we must also come to see the complexities of it in the lens of the big opinions on this. But one thing is beyond and above our differences: the compelling call towards a consistent victim-centered response against trafficking in persons. The chair recalls the visit of Professor Siobhán to Cebu, Philippines in May 2017 to introduce the Council of Europe's group of experts against trafficking in persons and other good practices that led to the efforts for the development of a focal point system for the national active representatives that ASEAN member states are planning to establish. Look forward to more engagement with Professor Siobhán as the UN Special Rapporteur on Trafficking in Persons. As one ASEAN, let's continue to press on towards the attainment of implementing the non-punishment principle.
Thank you so much, Excellency Assistant Secretary Morales, for your response to the address of Professor Siobhán. We now move on to our co-chair in AICHR Indonesia and recognize Excellency Wahyuningrum. Ibu Yuyun, you have the floor.
Thank you very much, Kim, and thank you very much, Professor Siobhán. And the non-punishment principle is very new for the discussion in the ASEAN Intergovernmental Commission on Human Rights, or AICHR. So indeed, your explanation and also the research done by Dr. Marika is very, very important for us to explore further on how we can bring together ideas and bring together some new norms, I should say, in ASEAN, and how to engage with ASEAN member states as well as ASEAN sectoral bodies in combating trafficking in person. It is very important and very interesting that you mentioned number of conventions that all ASEAN member states have ratified, like CEDAW, CRC, and CRPD. And mentioning these all conventions not only expand our horizon and understanding the non-punishment principle, but also expanding the AICHR mandate and coverage, as well as stakeholders and participation. So we are not looking at those who are working on women only or on trafficking only, but beyond this issue. And I thank you very much for highlighting this expansion of issues. I think as a characteristic of human rights is always interrelated, and it's universal. And also I would like to, I cannot speak on behalf of AICHR as a regional, but as AICHR Indonesia would like to welcome the possibility of engaging with you, bringing together ASEAN sectoral bodies as well as ASEAN member states to discuss further and to provide platform for learning and discussing some new norms. I believe that we cannot impose member states to embrace certain norms, but we can provide them with the platform in which they can learn each other, and then they can make decision how they can move forward with the new norms here. I can sense there is a tense between criminal justice and human rights in this relation of non-punishment principles, but I think this can be navigated throughout number of dialogues among different and relevant actors. And again, thank you very much for enlightening us with the issue and the topic with your expertise and a wide experience on the non-punishment principle. And thank you very much.
Thank you so much, Madam Co-Chair Ibu Yuyun, for your remarks as well in response to the address of Professor Siobhán Mullally, the UN Special Rapporteur on Trafficking in Persons, especially women and children. At this point, ladies and gentlemen, we have now come into the conclusion of our workshop. With the permission of the co-chairs, may we please move on into the closing remarks. Madam Co-Chair and Excellency Mr. Co-Chair. Thank you so much. Ladies and gentlemen, it is my honor to invite to the floor the team leader of ASEAN-Australia Counter-Trafficking, Dr. Lucia Pietropaoli, to deliver the closing remarks. Dr. Lucia, you have the floor.
Thank you very much, Kim, and thank you, co-chairs. I have the privilege of closing this important workshop, and I'd like to start by acknowledging our distinguished guests and speakers. Professor Siobhán Mullally, the UN Special Rapporteur on Trafficking in Persons, especially women and children. Our co-chairs, Assistant Secretary Morales and Her Excellency Ibu Yuyun Wahyuningrum, Ms Karla Juranek, the First Secretary of Development, Australian Mission to ASEAN from the Department of Foreign Affairs and Trade. We officially welcome you to your new role, and we hope you found this workshop useful as an introduction to some of the most complex issues in countering trafficking. Dr. Marika McAdam, the author of this study. Your Excellencies, ladies and gentlemen, first, I would like to sincerely thank the UN Special Rapporteur for your very astute and relevant insights on the importance of the non-punishment principle and its application in the ASEAN region and globally. Thank you so much for generously dedicating your time to this workshop, especially as it's early in the morning in Belfast. We're extremely grateful for your endorsement of our study, and we're thrilled to have you acknowledge the importance of this study, both to the ASEAN region and to the legal analysis and debate globally about the non-punishment principle. And we're so pleased that this report will contribute to your broader work on this critical issue in countering trafficking. I'd also like to thank ASEC Morales and Ibu Yuyun Wahyuningrum for agreeing to partner with ASEAN-ACT to host this event. The endorsement of this study by the Senior Officials Meeting on Transnational Crime and also the ASEAN Intergovernmental Commission on Human Rights is incredibly meaningful to us, as it adds significant weight, credibility and regional ownership to the findings and recommendations of this study. And of course, I would like to also congratulate and thank Dr. Marika McAdam, the author of this non-punishment study. This study is unique. It's the first of its kind to look at the practical application of this principle in this region. It's an incredible accomplishment, and it will make a significant intellectual contribution to regional and global debates and discussion on the issue. And finally, but most importantly, I'd like to thank all of you for your insights and candid reflections today on the findings and draft recommendations of this study. This was a very vibrant discussion, and it has highlighted the complexity of the issue and the challenges that are faced by multiple countries in this region in implementing the existing law and policy to protect victims, especially when it comes to children and young people. Your inputs will be carefully taken into account in finalising our study, and your contributions will undoubtedly make for a much better final product. Once this study is finalised and published, ASEAN-ACT is very eager to continue the dialogue with all of you on the application of the non-punishment principle. We are keen to continue dialogue with ASEAN sectoral bodies, and we thank you, Ibu Yuyun, for AICHR's commitment and enthusiasm in taking forward these discussions, and of course with all member states who are present today. And as First Secretary Juranek stated at the start of our workshop, ASEAN-ACT is here not just to support the research, but also to support work towards the implementation of the recommendations from this study. Ladies and gentlemen, the application of the non-punishment principle is inextricably linked to the protection of human rights of victims of trafficking. But as the Special Rapporteur so clearly articulated, we need to unpack what we mean by a human rights approach and consider the practicalities as well as the legal principles. In practice, this means the correct identification of victims is key to the application of the non-punishment principle. Special Rapporteur, we have also noted your points around disability, particularly intellectual disability, and how this may impact the process of victim identification and the consistent application of the non-punishment principle. This is something that our program would be very keen to do some further research into in the context of the ASEAN region. And of course, related to the application of the principle for children and young people, we note your recommendations around mainstreaming the principle into all law policy and practice around juvenile justice and child protection. This is timely and relevant for us as we have commissioned research on child justice systems in the ASEAN region, particularly as they relate to children, to child trafficking victims, and we will be developing a capacity strengthening plan for each ASEAN member state in consultation with ACWC, the ASEAN Commission on the Protection and the Promotion of the Rights of Women and Children. It is very clear from today's discussion and from the roundtables that we conducted to inform this study prior that there is strong convergence and strong commitment across the ASEAN region to implement the non-punishment principle. ASEAN-ACT, with the support of the Australian Mission to ASEAN, looks forward to working with all of you to strengthen law, policy and practice to ensure the non-punishment principle is applied fully and consistently across the ASEAN region. In doing so, we will contribute to the just punishment of perpetrators of trafficking and the paramount protection of its victims. I thank you again, Your Excellencies, for your participation today, and we look forward to continuing our work together to counter trafficking in the ASEAN region. Thank you.
Thank you so much, Dr. Lucia Pietropaoli, the team leader of ASEAN Australia Counter Trafficking. Before moving on to the final closing of this workshop, may I please invite everyone to another photo opportunity, this time with a special rapporteur, Professor Siobhán Mullally in the room. May I please invite our participants to kindly switch on your cameras, your videos. And you look at the camera, our colleagues from SOMTC Philippines will take the screenshots in 3, 2, and smile, please. There you go. The next panel, 3, 2, and smile. Thank you. The next one, 3, 2, and smile. Thank you. The next one, please. 3, 2, 1, smile. There you go. And the last one, ladies and gentlemen, 3, 2, and smile. I think my son will hate me for counting wrongly because I start with 3 and not in 1. So ladies and gentlemen, excellencies, thank you so much for your participation in this validation workshop on the important principle of non-punishment in ASEAN. We thank you for your insights. We thank you for the discussions. And thank you also for the interest and for your valuable time spent with us this afternoon. We also thank, on behalf of the organizers, of course, Nurul, our Victim Rights Director, who's been busy organizing this. Thank you also, Nurul, for making this possible. Of course, our author, once again, Dr. Marika McAdam, for being here with us and presenting this study. The technical team in ASEAN-ACT, our logistics team, Jenny, Ib, and Vicky, and other members of the team. SOMTC Philippines Secretariat, the tech team of SOMTC Philippines Secretariat, the documentation team also of the SOMTC Philippines Secretariat, and of course, our co-hosts, senior officials meeting on transnational crime, SOMTC Philippines. Thank you. The ASEAN Intergovernmental Commission on Human Rights, AICHR Indonesia, thanks to Ibu Yuyun and her team, and to the team of SOMTC Philippines, and the team of the Lead Shepherd on Trafficking in Persons in ASEAN. And that, my friends, is the end of this afternoon's affair. May you continue to be safe and healthy wherever you are, and enjoy the rest of the day. Mr. Chair and Madam Chair, on behalf of you, I close the program. Thank you, everyone.
Thank you. Thank you, everyone. Bye-bye. Thank you. Thank you, Cam.